you will be having a plenary session, no? So kaya nga ito yung pinakahuling breakout session nyo na magdi-discuss yung mga A-coaches. The rest, plenary session, and of course, dun sa discussion naman ng answers, of course, we will be the one to present it to this class, no? So magkikita-kita pa rin tayo after this synchronous session for the discussion of the answers na ibibigay after the session na doon sa plenary. So kaya nga by 3:30, no, by 3:30 dapat matatapos na ako sa dalawang topics ko on local legislation and IDM, the internal disciplinary mechanism, and the last two topics, no, which down to barangay assembly. This will be handled by Director Patrick. So tinatarget namin na before 5, no, at least 15 minutes before 5 o'clock, 4:45, mako-cover na namin lahat yung topics para you still have time to browse before your quiz this afternoon. Is that okay with you? Okay, so thank you very much.
Yes, Coach.
So ganito na lang, no, para hindi tayo matatagalan kasi medyo mahaba-haba naman yung natin yung discussion na naman. So kung may tanong talaga kayo na kailangan niyo talagang itanong, you can interrupt me, okay? But hindi na tayo tatagal, isang lang siguro, dalawang questions kasi sisiguraduhin natin that by 3:30 matatapos na yung discussion ko. Unless you have some questions talaga na you really need to clarify or based on sa reading. So because I understand yung gagawin namin dito from the very start is just a reinforcement of what you have read yesterday or even the past few days. So the assumption is may mga nalalaman na kayo na kailangan niyo lang i-clarify in this forum, no. So let's start discussing the question and the answer, no, for your last quiz. For the question number 1, this is codal actually. When shall the lupong tagapamayapa be authorized to bring together the parties for amicable settlement in the barangays? The 3 points, there are 3 items. The lupon shall have authority to bring together the parties if the following requirements are present. 1, parties are individuals or natural persons. No? That's the first requirement. Second is parties are actual residents in the same city or municipality. And lastly, subject matter of the dispute is within the authority of the lupon. So this is very important, no, insofar as the lupon tagapamayapa is concerned. Number 2, because it's 3 items, so 1 point each. Number 2, does the lupon have authority to handle disputes involving public officials or officers? 2 points. The answer is it depends. If the dispute involving a public official relates to the performance of his or official duties and functions, it would be cognizable by the lupon. Otherwise, it falls outside the authority of the lupon. For question number 3, explain briefly the following. That's 2 points, no? There are actually 4. First is respondent's actual residence rule. This rule on venue applies only when the dispute does not involve real property or interest therein, or the dispute does not arise at the workplace where the disputing parties are employed or at the institution where they are enrolled for study. So, yung rule ng venue natin dyan is will not apply, no, if that is the case. For the real properties location rule, this rule on venue applies only when the dispute involves real property, and such dispute must be settled in the barangay where the real property or larger portion thereof is located. So alam ko na discussed exhaustively by Attorney Ian, so no need to discuss. Unless you have some questions after the presentation of the answers, then we will discuss again, no? For the third concept, common workplace rule. This rule on venue applies only when the disputing parties are employed in the same workplace and the dispute arose at the workplace where the disputing parties are employed. So kapwa sila empleyado in that particular workplace. Or else, kung isa hindi dyan empleyado, then venue will, the workplace rule will not, the venue, no, will not apply doon sa provision natin. Then common place of study rule, parang ano lang to, workplace rule lang din ito. The rule on venue applies only when the disputing parties are enrolled for study in the same institution and the dispute arose at the institution where the disputing parties are enrolled. Parang similar lang ito doon sa workplace rule. No? Kapwa sila estudyante in that particular same institution. Number 4, what are the possible scenarios during the mediation proceedings? So number 1, these are the possible scenarios, no? 1, the parties may agree in writing to have the matter in dispute decided by the arbitration by the punong barangay. No? Take note of the word arbitration. In such a case, the arbitrational hearing shall follow the formal order of adjudicative trials. No? If the parties will agree na mag-arbitrate sila instead of mediation. The parties may proceed to amicable settlement through mediation. So dalawang option to, may arbitration at saka mediation. The parties may have not reached amicable settlement. Pwede din yan mangyayari, no? During the mediation proceedings. Then, failure to appear by any of the parties or both parties during the mediation. Pwede din yan. May mga consequences yan. Alam niyo yan, no? Number 5, objections to venue may be raised during mediation proceedings. Okay? Posible din na during the mediation, okay, proper, may isang party na magre-raise on mag-object doon sa venue, no? But the objection must be done at the mediation pa lang, kasi pagka alam naman ninyo, pagka hindi mag-raise ng objection, mapunta na doon sa conciliation, then that is considered waiver on the part of the parties na inaccept nila yung venue, no? Alam naman niyo yun. And then number 5, what if it was found out that the respondent's reason for not appearing before the pangkat ng tagapagsundo was not justifiable? So these are the consequences, no? If the pangkat finds, after giving the respondent an opportunity to explain his non-appearance, the failure to appear is without justifiable reason, its chairman shall first dismiss the respondent's counterclaim. So there is a certification to bar counterclaim that will be issued by the chairman ng pangkat ng tagapagsundo. And then this direct the issuance of an attest to the certification, this one, no, to bar the filing of respondent's counterclaim in court, government office using the KP form. May template na po tayo dito. And then to file complainant's action in court, government office using KP form number 20. Kahit hindi nyo na ma-mention yung KP form, no, that's immaterial. Ma-mention nyo lang dalawa, then you're good, no? And then number 3, apply with the local trial court for punishment of the recalcitrant party as for indirect contempt of court. So pwede siyang, may mga cases na po tayo na nangyayari ito, nagkakaroon ng indirect contempt. No? For number 6, may a disputing party repudiate the arbitration award. Medyo, yung iba dito nagkakamali, no? Medyo nalilito si. That's why you need to differentiate between arbitration and mediation. Okay? You really need to differentiate that. In most cases, ang ginagawa natin is mediation. Seldom tayong gumagawa ng arbitration kasi mahirap ito on the part of the arbitrator. Okay? Lalo na pagka yung mga, alam naman natin, yung mga punong barangays natin, hindi nga nila alam yung mga simpleng rules, no, on how to arbitrate. So magkakaproblema because in the arbitration there is always the presentation of evidence. Now, bakit hindi pwedeng bakit yung party hindi pwedeng i-repudiate yung arbitration award? Kasi repudiation award is considered as judgment after the presentation of the evidences by both parties. Kumbaga parang korte na ba? Oo. Unlike kasi dito sa mediation, which is amicable settlement, parang lang yung dalawang party nag-agree lang na ito na lang dapat gagawin natin. So that when there is this intimidation, di ba yung mga minention na ganon, then the other party has the right to repudiate the settlement. But it is within the reglementary period or the prescribed period within which to file the repudiation. Okay? I think that's very clear for you, no? Kasi may mga experience naman kayo dito. Then what is the two-tiered mode of enforcement of an amicable settlement under the revised Katarungang Pambarangay Law? That's 4 points. No? So number 1, by execution by the punong barangay, which is quasi-judicial and summary in nature, on mere motion of the party entitled thereto. And number 2, an action in regular form which remedy is judicial. So these are actually codal, no? And there are some cases cited in this in the answers. But you need not cite the case, just state the answer, then you can get the maximum points. Now let's proceed to the cases, no? Case problem number 1, which is question number 9. Medyo madali lang itong mga cases na to, no? Maluka purchased in installment basis a new motorcycle from Malandipa Motor Corporation. Despite repeated demands by the company, Maluka failed to pay her due. Maldita, an authorized collector of the company, filed a complaint in the barangay as instructed by the company lawyer. Does the Lupon have authority over the dispute? I hope maka-perfect tayong lahat dito. Ano kasi napaka-basic lang naman ito. Kasi one of the requirements dun sa question number 1 is yung tinatawag nating natural person dapat, no? Ang parties involved in the amicable settlement. In this case, alam naman natin na yung isa dito is not a natural person. It's a person under the contemplation of the law, but it's an artificial or a juridical person. Di ba? Now, of course, the answer is no, because the Katarungan Pambarangay, the Katarungan Pambarangay law requires that both complainant and respondent must be natural persons. In this case, the Lupon has no authority to settle the dispute because the complainant, Malandipa Motor Corporation, is a juridical person. No? So it is a person under the contemplation of the law, but it's not natural person. Okay? So the authority, the Katarungan Pambarangay, or the Lupon rather, has no authority to settle amicably the dispute. Hence, the Lupon has no authority over the dispute. Sana ma-perfect kayo doon, no? Nakuha niyo lahat 'yon, no? Hindi ko pa natapos na check yung papers. Question number 10. Canuto and Greco, ito is a question on I think on the venue, no? Canuto and Greco, who actually reside in Barangay Looc and Barangay Maslog, Danao City, respectively inflicted slight physical injury on Inyong, a resident of Barangay Poblacion, Danao City. Which Lupon has authority over the dispute? So it's actually jurisdiction. Since all parties actually reside in Danao City and the crime committed by the respondents is within the authority of the Lupon, okay? So there is the Lupon has the jurisdiction. So the dispute be brought either in Barangay Looc or Barangay Maslog, where the respondents reside at the election of Inyong. Siguro na-discuss naman ito, no? It's really the place of the respondents. So kung marami sila, depende na kung saan gusto ni complainant, no? Ipa-file yung kaso. Basta within those barangays kung saan nakatira yung mga respondents. I hope nakukuha niyo to, no? Question number 11. Last 2 questions. Canuto, an actual resident of Barangay Pulang Bato, Cebu City, is the city accountant of Danao City government. Inyong, an actual resident of Poblacion, Danao City, is currently assigned at the accountant's office as accounting staff of Canuto. Klaro yan. In the course of an altercation at the accountant's office, Canuto was inflicted slight physical injury on Inyong. Inyong brought the dispute to the Lupon of Poblacion, Danao City. During the first hearing, Canuto raised the question on venue invoking the rule on venue under Section 409, which is where the respondent actually resides. But Inyong invoked the common workplace rule under Section 409, which is the barangay where the workplace is located. Who is correct between Canuto and Inyong? The answer is neither of the parties. Why? The first thing to do is to establish the authority of the Lupon. That's the first thing, the jurisdiction. That's very basic. Okay? Before you will establish the venue. Okay. The first requirement is as to parties. As the Canuto and Inyong actual residents of the same city or municipality or their barangays adjoin each other. If the answer is no, the determination of the workplace of settlement is of no moment. So that's the ano. Kasi dapat kasi same workplace sila or at least adjoin yung mga barangays nila. Kasi kung hindi, then the barangays have no jurisdiction, no, to that particular conflict or dispute. Although the subject matter of the dispute is under the authority of the lupon, the parties are employed in the same workplace and the dispute aroused at the same workplace, but the parties do not reside in the same city or municipality, nor do their barangays adjoin each other. Therefore, no lupon shall have authority over the dispute, and thus there is no need to apply the rules on venue under Section 409 of RA 7160. So that would be all for your last quiz, no, that day 11 quiz. So far, any questions before we will proceed with our first topic of today, this afternoon?
Oh, Coach, Coach, this is Peter from R9. Coach,
Yes,
yung
yes.
sa question number 11 po ba, Coach? Di ba, Coach, mag-a-apply yung workplace? Venue sa workplace? Same employee naman sila. Same, same work sa isang munisipyo sila. Di ba dapat magko-comply yung sa barangay ng saan yung office nila nakasituate according sa rules o workplace, common workplace rule? Dapat doon sila masisettle na barangay?
Using the answer, actually, I'm just reading the answer, no?
Yes,
Neither of the parties is correct kasi you have to go back to the question. Inyong wrote the dispute to the Lupon of Poblacion, Danao City. During the first hearing, Noto raised the question on venue, invoking the rule on venue under Section 409, which is the respondent actually resides. So that's 409. And but you invoke the common workplace rule under 409 with letter D. Letter B si Kanoto, and inyong is letter D of 409, which is the barangay where such workplace is located. Who is correct between Kanoto and Inyong? So the answer is neither of the parties is correct, no? Kumbaga wala sa dalawa, because accordingly the first thing to do is to establish the authority of the lupon. Okay? Yun ang sinasabi ko sa inyo. Kasi immaterial naman kasi kung i-determine yung venue tapos wala parang authority si lupon. So it should be the first thing that you should determine is the authority of the lupon or its jurisdiction, no? So the first requirement is as to parties, no? Are they actual residents of the same city or municipality, or their barangays adjoin each other? So this is the requirement that the two parties, aside that they are working, aside that they are working in the same place, their actual residence should be the same or adjoin each other. Because if the answer is no, then the determination of the place of settlement is of no moment. So aside from they are working in the same workplace, no, you have to establish still their residence, no, of the parties. If they are living in the same barangays or adjoin with each other. Kasi kung hindi, accordingly, no need to determine the venue. Kumbaga, hindi siya dapat sakop ng katarungang pabarangay. Now, although the subject matter of the dispute is under, alam naman natin, luponable, no? Kasi based on the presentation of the facts, it's under the authority of the lupon. The parties are employed in the same workplace pa rin, pareho sila, and the dispute aroused at the same workplace, but the parties, naka-highlight ito sa answer key, but the parties do not reside in the same city or municipality, nor their barangays adjoin each other. Kasi pwede namang magkaiba yung magkaiba yung city or municipality, but mag-adjoin, kumbaga boundary and boundary, iba-ibang munisipyo. That's pwede din yun, no? Therefore, no lupon shall have authority over the dispute, and thus there is no need to apply the rules on venue under Section 409. So nakukuha nyo, it's not only based on the answer, no, na binigay. It's not only you will not only determine if the two parties involved are working in the same institution, but you need to consider also the residence of those parties. Because if those parties do not reside in the same city or municipality, or at least adjoining with each other, then no need to, or the determination of the place of settlement is of no moment. Is that clear?
Coach. Kala ko kasi workplace yung kung workplace yung magpe-prevail kasi yung situation kasi it's safe kasi po talaga sa workplace. Akala ko yun po talaga yung common workplace po. Akala ko po yun talaga. Sorry po. Sige po. Thank you po. Thank you for clarification.
Okay. So hindi siya absolute. Hindi siya ibig sabihin na pag nandun kayo, dalawa kayong nagtatrabaho or dalawa kayong nag-aaral for that matter, in that institution na automatic na. Kung may alitan kayo, may sigalot kayo, then automatic na doong barangay. You still have to consider your residence. Kasi nga po, in an ordinary, kung hindi ito workplace rule ang pinag-uusapan, kung nangyayari ito sa ibang lugar na hindi workplace, hindi itong barangay na ito na kung saan nakatayong yung school ang may proper venue, but it is the place kung saan nag-reside itong dalawang parties na to. Diba? That's the difference. Dito kasi silang dalawa nagtatrabaho dito, it's more practicable na dito na barangay sila dito itong barangay na to ang venue. But kung hindi lang ito kasi kung nangyayari ito sa isang bar or sa public places, it's not the barangay kung saan nangyari. This is an exemption kasi nga unlike in the criminal law na kung saan nangyayari yung isang krimen, doon yun ang may jurisdiction na korte. But here in the Katarungan Pambarangay, it's not the place where the conflict or the dispute na nangyayari, but it is the resident of the respondent. So, nakikita niyo yon. So, ibig sabihin, hindi lang talaga natin titingnan yung sa workplace rule at kahit naman doon sa pag-aaral, no, yung sa school, hindi lang natin titingnan kung silang dalawa nagtatrabaho doon at silang dalawa kasama doon sa school, but we need to consider also yung residence pa rin nila. Okay? So, I think that's clear already. Any question aside from that? Wala naman so far? Klaro na ba yon?
Klaro po, Coach.
Clear po, Coach. Clear po.
Clear po.
Okay, thank you. Yes, another question? Okay, so please give me 1 sec, mga 30 seconds to fix my presentation. We will start our first topic for this afternoon, which is local legislation. At itong local legislation ay napaka-related doon sa topic na i-discuss ni Attorney Moreno tomorrow. So you will be siguro bukas makikita niyo doon na ibang topics na tackle natin dito will be also presented during the presentation of Attorney Moreno. Okay? So moment please. can you see now my presentation?
Yes
Yes,
po.
coach.
Yes po, coach. Yes po.
Okay na ba? Okay, so shall we start now? Okay, so our first topic for this afternoon is about local legislation. This is
Yes, coach.
okay. This is provided under sections 48 to 59 of your local government code. No, meaning local government code of sections 48 to 59 speaks about local legislation. And alam naman natin pagka local legislation, naka-incorporate na po dito yung parliamentary rules, which is actually the topic of Attorney Moreno. No? So under section 48 of the local legislative power, it says that local legislative power shall be exercised by the Sangguniang Panlalawigan in the case of the province, the Sangguniang Panlungsod in the case of the city, and Sangguniang Bayan in the case of the municipality. Of course, sa Sangguniang Barangay, the lowest unit of the government, in the case of the barangay. Now, what is a sanggunian? No? A sanggunian is a collegial body. Okay, legislation, which is the principal function and duty of the sanggunian, requires the participation of all its members, so that they may not only represent the interest of the respective constituents, but also help in the making of decisions by voting upon every question put upon the body. Now, in the parlance of the parliamentary procedure, question meaning the subject. No, it's not really the question that is the same that we understand as question. No? This is actually the subject, the resolution, the ordinance, or the subject matter being taken up by the legislative body or that collegial body. The acts of only a part of the Sangguniang done, okay, the acts of only a part of the Sangguniang done outside the parameters of the legal provision aforementioned are legally infirm, highly questionable, and are more importantly null and void. So it has to be collegial, no, in making decisions so that it will not become null and void. And all such acts cannot be given binding force and effect, for they are considered unofficial acts done during an unauthorized session. So that is our definition of the legislation. Of course, klaro naman yan na pagka-legislation, it's really the sanggunian function. Now, Section 49 speaks about the presiding officer. Who is the presiding officer? In the case of the Sangguniang Panlalawigan, automatically, by virtue of the election and the position, it's the vice governor. The Sangguniang Panlungsod is the city vice mayor. For the Sangguniang Bayan, it's the municipal vice mayor. And for the Sangguniang Barangay, this is something unique. This is unique, no, in the barangay, because the local chief executive is at the same time, if you notice, the presiding officer. That is only for in the case of the barangay. Di ba nakikita niyo, napapansin niyo doon na si punong barangay, siya yung local chief executive, at the same time, siya din yung presiding officer, no? Siya yung presiding officer ng sanggunian. So, yan lang po ang kakaibahan pagdating sa barangay. Okay, may note tayo. The presiding officer shall vote only to break a tie. We will discuss this further as we progress with our discussion later. Question for under Section 49 as to the presiding officer. Is it still legally feasible for the vice governor, vice mayor, who is now the acting governor or mayor, to preside the legislative sessions? Di ba alam naman natin na pwedeng magiging, by rule of succession, si vice governor and vice mayor, pwede siyang magiging acting. Now, in that case, in that particular instance, when the vice governor will become an acting mayor, yung question dito is, pwede ba siya, legally feasible ba, si vice governor, vice mayor, who is now acting governor, na mag-preside sa legislative sessions? The answer is
No.
big no. Why? This is the answer, no. when the vice mayor and the vice governor becomes an acting local chief executive, he's actually a quasi-LCE. Di ba? He is deemed a non-member of the Sanggunian for the time being. In other words, you cannot be both a member of the Sanggunian and at the same time, you are the acting local chief executive. I think this is very basic, especially that ours under the Constitution is a presidential type, is a presidential form of government. At alam naman natin during your Constitution, when you have taken up your subject on Philippine Constitution, one of the basic tenets or the cornerstone of a presidential form of the government is the checks and balances of power. That's why we have this executive, legislative, and the judiciary. Under the Constitution, the executive, the president, the legislative, the Congress, judiciary, it's the Supreme Court or the judges. Now, the same thing, no? The same thing. This is actually aligned with the basic tenets of presidential form of government, wherein if the chief executive or the vice mayor, who is the presiding officer and a member of the Sanggunian, will be an acting mayor, meaning he's occupying the position of an executive, no? He is deemed a non-member of the Sanggunian for the time being. And as such, he can no longer preside the session. Kasi kung siya na mag-i-execute because he is the acting mayor, siya pang magpe-preside, there's no checks and balances. No? There is no checks and balances. And that is actually importante yan for a presidential form of government. This is in line with the principle of separation of powers. Actually, may doctrine na tayo dito, yung kay Gamboa Jr. versus Aguirre. You can see that. I will not discuss anymore the details of that case. This is where the issue on the vice mayor or vice governor who became acting LCA, yung question dun kung pwede ba siyang mag-perform as a presiding officer sa kanilang session sa Sanggunian. So the answer is no for the time being, since there was a temporary vacancy and siya yung nag-acting LCE. In the event of the inability of the regular, Section 49B, remember kasi importante ito. In the event, this is how you will choose among the members of the Sanggunian kung sino yung maging temporary presiding officer. Okay? Kasi nagkakaroon ng vacuum, nagkakaroon ng vacuum doon sa temporary presiding officer nung time na nagiging acting LCE si vice governor or vice mayor. No? In the event of the inability of the regular presiding officer to preside at a Sanggunian session, the members present and constituting a quorum shall elect from among themselves a temporary presiding officer. So magpipili sila doon. Hindi mag-a-apply dito kung magkakaroon ng inability, no, ng regular presiding officer na makapag-perform sa kanyang function, no. Hindi automatic na yung first high-ranking Sanggunian siya yung magpe-preside. But under the rules, no, under Section 49, the members present and constituting a quorum shall elect from among themselves a temporary presiding officer. He shall certify within 10 days. No? Take note, he shall certify yung na-elect na presiding officer, temporary rather, presiding officer, shall certify within 10 days from the passage of ordinance enacted and resolutions adopted by the Sanggunian in the session over which he temporarily presided. So kung ano yung mga resolutions or ordinances na napasa, no, or na-adopt during the time when he was the temporary presiding officer, siya yung mag-certify, no? Siya yung mag-certify within 10 days yung mga subjects or mga ordinance that were enacted or yung mga resolutions na na-adopt within 10 days na napasa. So kung sino yung magiging temporary presiding officer. Bakit no ang answer dito? Another question. When the vice mayor assumes office, he can no longer continue to preside, no? Kung pwede ba siyang mag-continue to preside, the vice mayor. He can no longer constitute to preside over the sessions of the Sanggunian, and the vacuum on the presiding officership has to be resolved by applying Section 49. So ito yung sinasabi natin na once the Vice Mayor will become an acting mayor, he can no longer preside. No? Klaro yan dito sa Gamboa versus Aguirre. So therefore, magkakaroon ng vacuum, and the process wherein magkakaroon ng temporary presiding officer, Section 49, yung earlier na discussion ko, yung mag-i-elect sila among themselves kung sino yung magiging temporary presiding officer. That is the procedure that they are going to follow kung magkakaroon ng inability for the time being, no, sa presiding officer. Just like when the vice mayor or the vice governor will become a temporary mayor or vice governor. Who presides the session in the absence of the regular presiding officer? So it depends on who shall be elected. So pabalik-balik ka, no? It's really Section 49 yung mag-govern pagka magkakaroon ng inability or magkakaroon ng vacuum doon sa temporary, doon sa presiding officer. So it depends on who shall be elected as temporary presiding officer by the remaining sangguniang members, there being a quorum. Take note of the word quorum, ha? Kasi sinasabi doon sa definition natin na it would be illegal, no? Illegal yung pag-transact ng business pagka walang quorum. Okay? It would be considered as null and void kung ano man yung mga resolutions enacted or adopted or ordinances enacted pagka walang quorum. So importante pa din in electing the members or in electing a temporary presiding officer, kailangan pa rin talaga palagi si quorum. Mag-discuss tayo mamaya kung what we mean by quorum and the majority. Okay? At saka yung mga requirements before a deliberative body can legally transact a business. May a temporary presiding officer be allowed to vote during session? Okay, under Section 49 pa rin yan. The answer is a big no. No? When acting as presiding officer, he may not at the same time be allowed to exercise the rights of a regular member, no? Including that of voting when there is no tie to break. Because a temporary presiding officer who merely steps into the shoes of the presiding officer could not have greater power than that possessed by the regular PO or presiding officer who can only vote in the case of a tie. There is the case of Zamora versus Caballero. So kung nagiging temporary presiding officer ka, hindi mo na mai-enjoy yung mga rights and privileges mo, especially sa pagboboto, for example, okay, your right to vote during when there is a subject or there is a question na magdi-divide yung house. So talagang if you are a temporary presiding officer, you really have to step, no? Doon sinasabi dito, the shoes of the presiding officer. And therefore, you could not have greater power than that possessed by the regular presiding officer. So being a presiding officer, you can only vote to break a tie, just like the regular or yung talagang elected na presiding officer, yung vice mayor or vice governor. Okay, I think klaro yan. No? What do you mean by the phrase duly certified by the presiding officer? Yung kanina, di ba? 10 days after ng enactment and adoption of the resolution, it has to be certified by the presiding officer. Now, the phrase duly certified by the presiding officer means that the vice mayor and presiding officer for that matter, or any temporary presiding officer for that matter, shall have certified that a session was indeed conducted, whereupon the ordinance to be submitted was deliberated upon and duly enacted by the sanggunian concerned. So yung pag-certify lang naman dyan is you will certify, yung PO naman, hindi siya discretion na ayaw niyang pirmahan kasi hindi niya nagustuhan yung pagkasulat or yung mga nandoon sa transcript. But yung purpose lang ng pag-certify niya is to really, i-certify niya na talagang nagkakaroon ng session and these items of the agenda were really discussed by the deliberative body. Okay, kung may nagkakaroon ba ng enactment of an ordinance or adoption of a resolution, isi-certify lang yan na talagang nagkakaroon ng discussion on the matter. Okay? So okay. So that's for the word certify kasi may mga question kasi dito lalo na pag nangyayari ito pagka nag-aaway-away yung sanggunian. May majority, may minority. Ito naman si Vice Mayor belongs to the minority. Ayaw niya yung mga move ng majority. So pipirmahan ba niya o hindi? Hindi yan discretion. It's ministerial on his part. Napipirmahan niya for as long as ito na yung isi-certify naman niya ay totoo naman, no? Ay totoo naman. So, yun po. Section 50 is on internal rules of procedure. On the first regular session following the election of its members and within 90 days thereafter, the Sangguniang concerned shall adopt or update its existing rules of procedure. I think this is one of the things or the topics that will be discussed tomorrow, no? The internal rules of procedure, because that will be part of your parliamentary rules, no? This will be discussed thoroughly siguro tomorrow by Attorney Moreno. So inaatasan under Section 50 na within, no, on the first regular session following the election of its members and within 90 days, no, thereafter the Sangguniang concerned shall adopt or update its existing rules of procedure. So yung iba naman kasi hindi naman talaga mag-start from scratch kasi may mga existing naman na mga internal rules of procedure. So what they will do, yung pagkaupo ng bagong halal, they have to revisit, they have to update, no, the existing rules of procedure. That is going to be the rules of procedure that will govern in their particular term of office. So ganun yon. So take note kasi may mga issues dito na since ni-require na, di ba, na on the first regular session, no, talagang i-discuss ng during the following election of its members, the Sangguniang concerned shall adopt or update its existing rules of procedure. May mga question kasi kung halimbawa kung wala pang approved na existing rules of procedure, hindi ba pwedeng mag-enact sila ng ordinance or mag-adapt ng resolution? May mga questions mamaya, okay? What governs the IRP of the Sanggunian? Ano yung nandoon sa internal rules of procedure? IRP is primarily governed by the following sources of parliamentary rules arranged in the following order. This is now the hierarchy, no, of the sources of parliamentary rules. Of course, yung pinakamataas dyan, the same, the Constitution. Okay? That's the source of the internal rules of procedure. Ibig sabihin, hindi kahit na si local government, si local legislative body is mandated to come up with an IRP, ibig sabihin, hindi pa rin sila pwedeng gagawa ng IRP na in conflict with the Constitution. Okay? It is within it is always aligned, no, doon sa Constitution, and that is the highest source of parliamentary rules. Second is of course the Local Government Code of 1991. May mga substantive tayo dito, may mga laws tayo dito sa Local Government Code that has to be considered in crafting their parliamentary internal rules of procedure. So dapat isaalang-alang palagi yan. And then of course, the Supreme Court decisions, yung mga doctrine natin, yung mga jurisprudence, and then adopted internal rules, yung mga rules na ina-adapt ng mga sanggunian, respective sanggunian. And if ever, no, kasi may mga gray areas pa rin yan. Kalimbawa sa in the parliamentary rules tomorrow i-discuss yan. May mga areas na hindi na-discuss, hindi mo makita sa Constitution down to the adopted internal rules, then what will govern is the parliamentary practice, no? The parliamentary practice, kung ano yung yung mga nasanayan na. And the last is the parliamentary authors. Now, we have actually respected authors on parliamentary rules. For example, the Book of Orindain on parliamentary rules that will be adopted in the event na may mga issues na hindi ma-address or hindi makikita from the Constitution down to the parliamentary practice. That's the hierarchy, no, ng sources of parliamentary rules. And of course, customs and usages. That's under DILG Opinion 14 series of 2005. Okay? Yung mga nakasanayan na. Okay? Nakasanayan na. Bakit yes? Okay. On the first regular session following the election of its members and within 90 days thereafter, the Sanggunian concerned shall adopt or update its existing rules or procedure. That is actually based on Section 50 of RA 7160. Okay? Yun talaga yung nakasulat sa ating code. Okay, question. Does the law requires the completion of the updating or adoption of the internal rules of procedures before the Sanggunian could enact an ordinance? Okay? Kung baga, ni-require ba ng batas based on Section 50 na magkakaroon muna ng internal rules before the Sanggunian could enact an ordinance? Anong sinasabi natin? Hindi. Why? Based on the code, Section 50, it simply requires that the matter of adopting or updating the IRP be taken up during the first day of the session. Hindi naman ibig sabihin na during the first session talagang they will complete the updating and the approval of the new IRP. Ang sinasabi lang doon, they have to take that up during their first day of session and within 90 days. So ibig sabihin na pwede pa rin silang magpasa ng ordinance or mag-adopt ng resolution in the absence, while the IRP is the process of reviewing and hindi pa na-approve basta within 90 days. So may case tayo diyan. Kasi niripaso ng isang mayor dito, niripaso ng isang mayor ang isang ordinance kasi nga wala pa daw IRP. So ito yung sagot na hindi magiging hadlang si IRP na hindi mapasa yung isang ordinance or hindi ma-adopt yung isang resolution. Kasi what the law says in Section 50 na iti-take up nila during the first session na kung kailan sila na-elect. Hindi sinasabi na they cannot proceed with their transaction as to the enactment of an ordinance or the adoption of resolution without the IRP. Ganun po yung sinasabi ng Supreme Court. Now, can a legislative act be declared invalid for non-compliance with internal rules? So, tingnan natin yan. The answer is no. Why? The disregard of internal rules would not affect the validity of the law. We have already a case on ito yun, Arroyo versus De Benicia. This is a Supreme Court decision. Okay? For as long as the legislative act, for example, the ordinance followed the requirements. For example, the ordinance, for example, that was enacted, followed strictly observed the formal and the substantive requirements para magiging ordinance, then kahit na may disregard doon sa internal rules, the ordinance will not be affected. Okay? So, ano ba yung mga sinasabi kong substantive na mga requirements at saka procedural or formal requirements? I will discuss that to you later on how the ordinance will become valid. Of course, they have to go through those processes and parameters. Yung dalawa na it should be, there is the requirement on the substantive and the formal requirement. So, I will discuss that later, The rules of procedure shall provide for the following. Okay? Ito yung i-discuss bukas ni Attorney Moreno. Ito yun, ang laman ng procedure. First, the organization of the Sanggunian and the election of its members, as well as the creation of standing committees which shall include but shall not be limited to the committees on appropriations. All those committees, those are just the minimum, but they can even add some. Kaya napapansin natin sa mga local legislative bodies, may mga ibang committees sila depending on the need of creating such committee. They are at liberty to create their own standing committee na sa tingin nila ay kailangan. Okay? So that's the content of the IRP, the rules of procedure. And then nandun din sa rules of procedure, the order and calendar of business for each session. So nakalatag din dyan. And then the legislative process, kung paano magiging ordinansa ang isang panukala, like how many readings, anong gagawin dun sa first reading, anong gagawin sa second reading, and then the third and the final reading. So yun yung legislative process, the flow, yung mga 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 item na i-take up ng sanggunian. And then number 4, the parliamentary procedures which include the conduct of members during session. So nandun din yan, no? Nandun din yan yung tinatawag nating decorum. The proper conduct of the members of the members of the sangguniang during sessions. Kasi may ano diyan eh, may penalty diyan, may parang kaparusahan yan. Once you have adopted your parliamentary rules and procedures, internal rules of procedure, and then there is a violation. Halimbawa, isang member hindi sumunod doon sa tinatawag nating decorum, then depende kung anong nakalagay diyan sa IRP nyo, then that member will be meted with that kind of sanction or penalty for that matter. Bakit it depends? Okay. Actually, ang question I think dito is kung si Vice Mayor ba, kasi may sinasabi tayo kanina doon sa rules of procedure, mag-provide siya ng mga committees, the standing committees. Ang tinatanong dito kung si Vice Mayor ba being the presiding officer, di ba? Automatic si Vice Mayor bilang presiding officer. Kung pwede ba siyang maghawak ng isang committee. Okay? So the answer is, if the sangguniang sa IRP allows the Vice Mayor, who is likewise the presiding officer, to chair a particular committee, then the same should be respected. So meaning, kasi silent naman sa local government code, hindi natin makikita doon na si Vice Mayor, at maliban sa magiging, ang talagang function niya basically is presiding officer. Hindi sinasabi na pwede o hindi siya pwede magiging committee chairman ng isang komitiba. But then, sinasabi dito, if the IRP, Internal Rules of Procedure, nag-aalaw sa isang Vice Mayor na humawak ng isang particular committee, then the same should be respected. However, should the sanggunian's IRP fail to address the issue, application of accepted parliamentary practice is in order, wherein an august body's presiding officer is only allowed to chair a special committee but not regular or standing committee. Kasi ganun yung nagiging parliamentary practice, that the presiding officer will not hold any chairmanship of the regular committee except for some special committee. Kung silent doon sa IRP na explicitly stated that the Vice Mayor can hold, can be a chairman of a particular committee, then what will apply is the so-called parliamentary practice, wherein the presiding officer is only allowed to chair a special committee but not regular or standing committee. So, ang magiging determining factor pa rin natin kung magiging ano pa siya, kung si Vice Mayor or Vice Governor can be a chairman of a particular committee, it is the IRP, yung mag-govern yan. Okay? Otherwise, balik tayo doon sa parliamentary practice. Thank you. May the selection of committee chairman and members be done through appointment. Ito, palagi itong tinatanong sa amin during the after elections, barangay man o ano. Of course, klarong-klaro yan sa local government code na the selection of committee, and even nasa ano yan, may opinion na po tayo dyan sa DILG, aside from section 50. The selection of committee chairman and members must be done by election. Kaya nga napapansin nyo, mahalaga sa isang sanggunian yung majority kasi it's a numbers game. Kasi yung mga juicy na mga committee, siyempre malagay talaga yan sa majority. Kasi kung mag-i-elect yan, siyempre mananalo palagi itong majority. Di ba? So kaya nga, parang sa Congress lang din. Kung sino yung super majority dyan, sila na mismo yung mag-a-assign. Although, in reality, election naman yan, pero kasi medyo balugo naman kung isa-isahin mo mag-elect, ginagawa naman yan in practice, nagko-caucus sila. Kaya nag-uusap-usap na sila na ikaw, ito, ikaw. And so that when the time comes na mag-meet na sila during in that particular session, no questions na, no debates, but just mere nomination and then second motion and then closed nomination and then that's it. Kasi may usapan na sila. Pero hindi yan ibig sabihin na ina-appoint yan. Talagang selected yan. No? Siniselect yan ng lahat ng members of course by majority, by the majority. So I hope klaro tayo dyan na yung mga committee chairman and members be done through, not through an appointment, but selection. May the Vice Mayor as presiding officer yield his chair, no, temporarily so he can participate in the floor deliberation. Alam naman natin ito. No? In the absence of any prohibition in the IRP of the Sanggunian. So, balik na naman tayo sa IRP. No? The Vice Mayor yields his chair temporarily so that he can participate in the floor deliberations. Ito yung parliamentary practice natin na pwede. The Vice Mayor may yield his chair so he can participate in the deliberation. But if ever there is really an explicit provision in your IRP that the Vice Mayor cannot relinquish or cannot yield his chair for him to participate, then it is the IRP that will govern. Okay? Now, provided that upon the termination of the deliberation, he shall reassume the chair for the purpose of taking of the vote on that particular matter to be voted upon. So, pwede siyang mag-yield or temporarily i-yield niya yung chair para mag-join sa debate, but during the division of the House, no, kung pagbubutuhan na yung isang question na yon, then he has to reassume the chairmanship. Because klarong-klaro doon that the presiding officer, babalik na naman tayo doon sa provision na earlier diniscuss natin, na the presiding officer cannot vote but he can only vote in case of a tie. He can participate, but he cannot vote on a particular question. He can only vote in case of a tie, to break a tie. Okay. The discipline. Kasali pa rin yan sa internal rules of procedure. No? The discipline of members for disorderly behavior and absences without justifiable cause for 4 consecutive sessions, for which they may be censured, reprimanded, or excluded from the session, suspended for not more than 60 days, or expelled, no? Provided that the penalty of suspension or expulsion shall require the concurrence of at least 2/3 vote of all the Sanggunian members. So mas malaki ang boto na kinakailangan, no, pagka ganitong issue ang kanilang iti-take up. Provided further that a member convicted by final judgment to imprisonment of at least 1 year for any crime involving turpitude. Alam naman niyo ito, concubinage. This was, I think, discussed during the presentation of Director Patrick. The crime involving moral turpitude shall be automatically expelled from the Sanggunian. Okay? So, such other rules as the Sanggunian may adopt. So, discuss natin yan. Okay? So, dito. May the Sanggunian use its internal, may question, wala naman siyang question, klaro naman ito, na hindi pwedeng magpataw ng termination, no? Si Sanggunian, because that is an ultra vires, that is beyond the authority of the Sanggunian. Ang pinakamataas lang na suspension na sanction na maibigay yung Sanggunian is a 6-month suspension. But in the case of termination, hindi yan, because it's only the regular court or the proper court yung may jurisdiction or may authority to terminate or to expel, no, kasi yung sinasabi natin dito, do not be confused, kasi may sinasabi dito din that the penalty of suspension or expulsion shall require, yung sinasabi nating suspension, ito yung masuspend siya a maximum of 6 months. Yun lang talaga ang pinakamahabang suspension na pwedeng maipataw. Administrative case kasi, administrative to, na pwedeng maipataw ng isang Sanggunian. Yung expulsion na sinasabi dito, hindi to expulsion gaya ng last sentence of this paragraph na automatically expelled from the Sanggunian. Yung expulsion na sinasabi dito, expulsion doon sa particular session. Okay? Halimbawa, may conduct unbecoming siya or hindi maganda, is not observing the proper decorum during the conduct of the session, then pwede siyang i-expel, no? Expulsion as to that particular session only. Hindi ibig sabihin na matanggal siya sa kanyang pagkagawa. You have to differentiate that. Unlike dito sa last paragraph na sinasabi na kung may crime siya and there was a final judgment for imprisonment of at least 1 year for any crime involving moral turpitude shall automatically expelled from the sanggunian. These are two different things. Yung expulsion na sinasabi doon sa taas at saka expelled na sinasabi dito sa last sentence of this paragraph. I hope di tayo malilito dyan. May the sanggunian use its internal discipline mechanism against a sanggunian member for actions done outside the session. I think this is the topic of our next. This is part of our next topic doon sa internal discipline mechanism. No, we are talking here of the internal rules of procedure pa rin na dapat nandoon sa IRP. So the answer is no. No, hindi pwedeng matawan ng isang disciplinary action based on the internal discipline mechanism nila yung outside the session. The acts constituting the grounds must be committed in relation to or on occasion of or during the session. Yun lang ang sinasabi dito. Acts committed outside the session or not related to the session of the sanggunian cannot be subject of internal disciplinary actions that can be imposed by sanggunian. Okay? So, meaning, pagka ang isang kagawad nag-a-act ng sumisigaw, for example, doon sa isang kagawad na outside the session naman, hindi magagamit si internal rules of procedure. Okay? Hindi siya pwede gamitin. Magagamit lang siya if acts committed, pagka nandun lang sa on occasion of or during the session. So outside the session or not related to the session of the sanggunian cannot be the subject of internal disciplinary actions that can be imposed by the sanggunian. That was, we have actually a DILG opinion number 83, series of 2004. Now, nandun pa rin sa full disclosure of financial, section 51 na tayo, no? Full disclosure of financial business interest of sanggunian members. Every sanggunian. Yes, any question? Okay. Every sanggunian member shall, upon assumption to office, make a full disclosure of his business and financial interest or professional relationship on any relation by affinity or consanguinity within the fourth civil degree which he may have with any person, firm, or entity affected by any ordinance or resolution under consideration by the sanggunian of which is a member, which relationship may result in conflict of interest, and such relationship shall include. Alam naman natin na, di ba, na-discuss, ako pa nga nag-discuss nun junta sa topic ko that pwede silang mag-practice ng kanilang profession, the sanggunian, right? But during parang tayo lang din, no? Pagka-elect nila, kailangan talagang i-disclose nila lahat ng business and financial interest and other mga professional or professional relationship, no? Kasi para ma-establish doon kung ano talaga yung mga business nila para pag magkakaroon ng isang for example, question or isang ordinance or isang resolution na magkakaroon ng kasama, no, na may relationship doon sa kanilang financial interest or sa kanilang business, then importante na ma-establish yan. Kasi kung hindi ma-establish yan, hindi natin malalaman if there is really a conflict of interest, lalo na kung halimbawang kasi may case tayo dito para lang maintindihan natin, no. May isang vice mayor na yung nanay niya may-ari ng isang hardware, no? At saka being the vice mayor, siya yung nag-a-approve ng mga purchases, mga ganun. So kaya kinasuhan siya kasi doon sa nanay niya, no? Di ba? Doon sa nanay niya bumili ng mga hardwares na yon. So kailangan talagang may establish yun para malaman natin kung there is really a conflict of interest. Pero hindi natin pinagbawalan, no? Gaya na sinasabi nila, practice of profession, that sanggunian na magpa-practice ng kanilang profession. Now, such relationship shall include, ito, dapat may establish, no? Ownership of stock or capital or investment in the entity or firm to which the ordinance or resolution may apply, and contracts or agreements with any person or entity which the ordinance or resolution under consideration may affect. Halimbawa, may contract na pag-uusapan, yun pala ang contracting party is the LGU, kayo yon ang magde-decide, and yung business mo. So magkakaroon yan ng conflict of interest. You will not become objective now in favor of the government because may sarili kang interest doon sa isang business na yon na kasama ka na isa ka doon sa may-ari, for example, or yung pamilya mo ang may-ari. So importante yan that there should be full disclosure of financial and business interest of the Sangguniang members. Makikita naman natin to doon sa pagpa-file natin ng SALM, statement of yan sa asset and liabilities natin. In the absence of a specific constitutional or statutory provision applicable to this situation, this is now the definition of conflict of interest. No? Conflict of interest refers in general to one where it may be reasonably deduced that a member of Sanggunian may not act in the public interest due to some private, pecuniary, or monetary or other personal considerations that may tend to affect his judgment to the prejudice of the service or the public. So may mga tayo dito, may mga ang daming cases natin dito. Si Solgen nga, isa yan sa pinag-usapan kasi yung security agency niya yata is one of the siya yata ang sa may-ari or things like that, no? Even si Secretary Duque, di ba? May mga things like that, no? Kasi hindi na magiging objective. That is for the cabinet, no? Iba naman to sa elected officials. So, may mga cases na to, no? Na ikaw may-ari, hindi mo dinisclose, and then there is a contract to be entered between the LGU where you are representing, and then yung business is yung kasama ka. The disclosure required under this act shall be made in writing and submitted to the Secretary of the Sanggunian or the Secretary of the Committee of which is a member. The disclosure shall in all cases form part of the record of the proceedings and shall be made in the following manner. So this is actually codal, no? Yung sa disclosure. I'm not going to discuss this further. Okay? Disclosure shall be made when a member takes a position or makes a privileged speech on a matter that may affect the business interest, financial connection, or professional relationship described therein. Okay, so can we have a 3-minute break kasi may importante lang akong ipipick up na call. Okay, so I'll be back in 3 minutes. Thank you. Hello, I'm back. Are you still there? Diyan pa kayo?
Yes, Coach.
Okay. So far may tanong ba before I proceed with the section 52 on sessions? Wala naman. Sige. Kasi I have to finish everything by 3:30 to give way to our next presenter, si Director Patrick. So isahin na lang natin, no? Kung may time tayo before 3:30, so you can ask questions. Just jot down notes dun sa mga questions. I will answer your questions later na lang, okay? So for the meantime, let me proceed with my presentation. So Section 52 speaks about sessions. No? So on the first day of the session, immediately following the election of its members, the Sanggunian shall, by resolution, no, fix the day, time, and place of its regular sessions. So pag-usapan nila ng during the first day, yun talaga, no? During the first day of their regular session, of their session. The minimum numbers of regular sessions shall be once a week. Ito yung mga requirements. Minimum meaning this is non-negotiable. Okay, pwedeng sumobra, hindi pwedeng makulang, no? This is the minimum. Shall be once a week for the Sangguniang Panlalawigan, Sangguniang Panlungsod, and Sangguniang Bayan, and twice a month for the Sangguniang Barangay. So that's the minimum requirement for in the conduct of regular sessions in the legislative bodies. When public interest so demands, special sessions may be called by the local chief executive or, no, may dalawang pwedeng magpatawag ng session, ng special session. The chief executive or by a majority of the members of the Sanggunian. That is in the case of a special sessions. Of course, hindi natin alam yan yung schedule kasi special na eh. But as the need arises. Letter C, in your section 52, all Sanggunian sessions shall be open to the public and this closed door session is ordered by an affirmative vote of a majority of the members present, there being a quorum in the public interest or for reasons of security, decency, or morality. Ito lang yun. Ito lang yung mga exceptions kung kailan magiging closed door session ang session ng ating legislative bodies. For reasons of security, decency, and morality, but it has to be approved. Okay, it has to be affirmed. It has to be approved by the majority of the members present during that particular session, there being a quorum. No two sessions, regular or special, may be held in a single day. So hindi pwedeng dalawang session mangyayari sa isang araw. Session tayo para lang makabawi ba kasi sinasabi natin na for the barangays kailangan nila ng dalawang sessions. Then they will try to circumvent the law. Magkakaroon sila ng ibig sabihin dalawang separate na araw. Yan, hindi pwede na dalawang sessions sa isang araw. Okay? So ibig sabihin yan pag sinasabi natin dalawang sessions, that would mean dalawang araw regardless kung anong days yun, basta it should be done on a separate day, no? It should not be held in a single day, yung dalawang sessions na. In the case of special sessions of the Sanggunian, a written notice to the members shall be served personally at the members' usual place of residence at least 24 hours before the special session is held. So remember, kahit na special session yan, there is always the service of a written notice, no? And it shall be served personally, okay? Kahit na sinasabi nating special session yan. Unless otherwise concurred by 2/3, no, of the Sanggunian members present, there being a quorum, no other matters may be considered a special session except those stated in the notice. Ganun naman talaga ang rules dyan, di ba? Pagka special session, yung iti-take up niya, kung ano lang yung nandyan sa notice na pinadala. No other items will be taken up without yung mga hindi nasama doon sa written notice. Kaya nga special kasi may iti-take up lang kayo na napaka-importante that you need to discuss it, for example, today, because it would be too late if you will discuss it on your scheduled regular session. So ganun yun. So hindi kailangang mahaba. Pero may exemption tayo dito. Pwede kayong mag-take up other than those written in the notice. However, there has to be concurrence of the 2/3 vote of the Sanggunian members present, there being a quorum. No, each sanggunian shall keep a journal and record of its proceedings, which may be published upon resolution of the sanggunian concerned. Actually, this is the function of the sanggunian bayan panglungsod or panlalawigan secretary to keep a journal and record. Bakit yes? Okay. Okay. Ang question kasi dito, kasi di ba yun sa legislative process natin, may 3 readings yan eh. First reading, second reading, and the third reading. Yung first reading niyan, ay discuss yan bukas ni i-discuss yan bukas ni Attorney Moreno. Ito na yun. The first reading, it has to be calendared, refer to the appropriate committee. Second reading, yun na yun, magre-report na, tapos ka mag-report, tapos nang nag-conduct ng public hearing yung committee na na-refer, and then mag-report na, and then discussion, and the third and final reading is the yung pagbubutuhan na, yung panukala, yung ordinance or resolution man yon. So, ganun yung magiging sinatawag nating 3 readings. So, ang tanong dito kung pwede ba yung 3 readings, first, second, third readings, mangyayari sa isang araw. Sinasabi dito, yes, there is nothing in the law which prohibits that the 3 readings of a proposed ordinance be held in just one session day. That is the case of Malonzo versus Zamora. Okay? May mga ordinance ba na napaka-importante? Lalo na ngayon, may mga COVID tayo na may mga COVID ordinances tayo na nire-require doon sa LGUs. Kadalasan ginagawa niya dyan kasi minamadali din natin doon sa monitoring natin sa DILG. Kadalasan dyan, pina-fast track nila yan. Oo. And then, yung 3 readings mangyayari in just one day to make it, to enact such ordinance. Okay? Yan din kung hindi na kailangan ng public hearing. But later in my presentation, you will realize that there are actually ordinances that will be enacted that really needs public hearing as a requirement, as a requirement later. Ito, the quorum, pag-usapan natin to. What do you mean? Section 53 talks about the quorum. A majority of all the members of the Sanggunian who have been elected and qualified. Take note of this term kasi may differentiation, may kakaiba to doon sa constitution natin na sinasabi lang who have been elected. But in our local government code, may kasamang qualified na naka-highlight pa dyan, no? Quorum a majority of all members means that a majority of all members of the Sanggunian who have been elected and qualified shall constitute a quorum to transact official business. Take note of the words majority of the elected and qualified. No? Should a question of quorum be raised during a session, the presiding officer shall immediately proceed to call the roll of the members and thereafter announce the results. So kadalasan lalo na dyan sa Congress, no? Pag nakikita ng isang member dyan na parang kulang yata, parang nawawala, parang hindi na yata aabot sa majority, then there is always, then someone will question the quorum, and then if there is someone who will question the quorum, ang gagawin niya ng speaker is, or in the case of the Sanggunian, ang presiding officer shall immediately call the roll of the members and thereafter announce the results to determine kung may majority pa rin, and that constitute a quorum. Okay? Now, what is a quorum now? The number of persons, this is the definition under section 53, no? Quorum is the number of persons of deliberative body, okay, or the legislative body in the case, which legally assembled in their proper places will enable the body to transact its proper business, or that number which makes a lawful body and gives it power to pass upon a law or ordinance or do any valid act. So we have a case here of Abiliana versus Tayo. Okay? So kabuuan to, no? The quorum really constitutes the number of persons of a deliberative body. It's all the members, no, of the deliberative body. So but when we speak of gito, the majority, no, kung paano natin i-determine yung majority na in a quorum, ito yung definition natin. We will explain further this. We have examples doon sa later doon sa quorum. The applicable rule on quorum of local legislative bodies is found in Section 53. No? You can read your local government code, no, of local government code of 1991, which provides that a majority, okay, ito yon ang definition, ang rule of quorum in a local legislative body under Section 53. It's a majority of all members of the Sanggunian who have been elected, again, binalik na naman in Section 53, qualified, shall constitute a quorum to transact official business. So pag sinasabi natin quorum, dapat majority yan na lahat ng members of the Sanggunian, may it be Sangguniang Bayan, Sangguniang Pangunsod, Sangguniang Panlalawigan, or Sangguniang Barangay for that matter. No? Lahat ng members who have been elected and qualified shall constitute a quorum to transact official business. So hindi lang ibig sabihin yung na-elect, but kailangan doon sa na-elect, nag-qualify din. Kasi pagka hindi sila nag-qualify, hindi siya dapat kasama doon sa computation natin of yung sa determining kung ilan yung members natin ng sanggunian or local legislative body. That is now the difference. Kaya may word dito na elected ito and qualified. Kasi posible naman kasi, like for example sa sanggunian, halimbawa 8, may hindi na-qualify, may hindi na-proclaim. So ibig sabihin, yung computation natin hindi na 8, it will be 7. Ganun yun. That's the idea of this provision. That is I think the intent of this provision, no? Na sinama dito yung elected and qualified. And I believe there is a case na talagang diniscuss the difference between the provision in the Constitution na nagsasabi lang na elected, kay all members elected, and here in the local government code qualified, elected and qualified. Now, Section 53 pa rin. The entire membership must be taken into account in computing the quorum of the Sanggunian. For while the Constitution, ito yung sinabi ko, Constitution merely states that majority of each house shall constitute a quorum. Section 53 is more exacting as it requires that majority of all members of the Sanggunian elected and qualified shall constitute a quorum. Mas masyadong exacting ang local government code kasi talagang kina-qualify nila. No? Then the determination of the existence of a quorum should be based on the total number of members of a Sanggunian without regard to the filing of leave of absence. So iba naman yon yung sinasabi natin na filing of leave of absence. Yung nagpa-file ng leave of absence, talagang kasama yan doon sa pagkukompute natin ng in determination of the total members of the Sanggunian. However, yung sa hindi nag-qualify, yun yung hindi natin isasama sa pag-determine ng total number of members of the Sanggunian. Importante kasi na ma-determine natin yung total numbers kasi yung sinasabi nating majority, it's the more than half of any total. So dapat may benchmark, may basis tayo kung ano yung total natin. Diba? So kailangan yan kasi in determining the more than half of any total, sinasabi natin 50% plus 1, dapat may establish natin muna kung ano yung total. So yun. Sinasabi natin pagka qualified, in determination of the quorum, hindi isama yung hindi qualified, hindi elected and qualified, yung hindi na qualified. But doon sa mag-file ng leave of absence, of course, kasama yan sa pag-determine ng total numbers of the Sanggunian. And election to and qualification as member of a local legislative body are not altered by simple expedient of filing or a leave of absence. So, ibig sabihin nga, hindi pwedeng ma-alter, hindi pwedeng ma-minus yung total number of membership by mere filing of a leave of absence. So, kailangan pa rin natin ng ano yan. Kailangan pa rin natin na isama yung mga nagpa-file kahit na approve yan na leave of absence, but then kasama yan sa determination natin ng pag-establish natin ng total number of members para makuha natin yung tinatawag natin na quorum. Now, only qualification is material in the counting of a quorum. The filing of a leave of absence does not affect the member's material qualification or election. Hence, a quorum shall be based on the total number of members without regard to the filing of a leave of absence. So may case tayo dyan, the case of Zamora versus Caballero. no, in the determination of the total numbers of the legislative body. And election to and qualification as member of the local legislative body, ay ito na, pabalik na. Okay, so pupunta tayo doon sa majority na sinasabi natin to in determining if there is a quorum, then it has to be a majority of all the members present. No? So majority when required to constitute a quorum, yun naman talaga ang requirement natin ng quorum, no? It's a majority. It means to say the number greater than half or more than half of any total. That's Perez versus De La Cruz and Zamora versus Caballero. Kasi yung sinasabi natin 50% plus 1, that is the majority. Or more than half of any total. Kaya nga, importante talaga, before we can determine the more than half of any total, we really need to get the numbers, the total numbers, or the total numbers, kasi yun ang basis natin in determining the more than half of that total. So, importante yan kasi baka i-question, di ba sabi ko sa inyo, pagka walang quorum, walang yung transaction, parang illegal yung pag-transact ng business. Kaya pwede siyang i-question, halimbawa nag-meeting yung sanggunian, wala namang quorum, no? Wala namang quorum, then pwedeng i-contest yan as null and void. Saka kailangan talaga na before the start of any transaction by a deliberative body, dapat ma-establish at masigurado na may quorum. At kung paano i-determine, ito yon. Okay? It's the number greater than half or more than half of any total. Section 53 pa rin, no? Where there is no quorum, the presiding officer may declare a recess kasi walang mangyari until such time as a quorum is constituted or a majority of the members present may adjourn from day to day and may compel the immediate attendance of any member absent without justifiable cause by designating a member of the sanggunian to be assisted by the member of or members of the police force assigned in the territorial jurisdiction of the local government unit concerned to arrest the absent member and present him at the session. So kung halimbawang wala talagang quorum yan, kasi alam naman natin na useless, it will be an exercise in futility kung gagawa sila ng mga ordinansa, mag-enact sila or mag-adapt ng resolution kung walang quorum, kasi that's considered as null and void, no? Hindi yan that's not they cannot legally transact a business kung walang quorum. So ang gagawin diyan, two options. It's either the presiding officer may declare a recess for lack of quorum or upon the decision of the majority of the members present during that particular session, pwede nilang i-compel yung mga ibang members. Mangyayari kasi ito pagka halimbawang yung presiding officer, kalaban, ang sa kanyang mga alliance siguro 2 lang o 3, and the majority siguro sa kalaban magbo-boycott sila, hindi sila mag-a-attend ng session. So walang mangyayari talaga doon sa kanilang session. So the other option is ito, no? I-require talaga yung physical presence ng mga nag-absent. They can even ask the assistance of the members of the police force assigned in the territorial jurisdiction para to arrest the absent member and present him at the session. So parang may force na talaga na i-apply para na to ensure na mag-a-attend sa session at mako-constitute ang quorum so that they can transact legally the business. So those are the two options, no? If there is still no quorum despite the enforcement of the immediately preceding subsection, no business shall be transacted. So klaro talaga yan, no? Klarong-klaro yan. No, kahit na anong ginawa na nila, hindi pa rin nila makuha yung numbers to constitute a quorum, so talagang walang mangyayari. Okay? So the presiding officer, upon proper motion duly approved by the members present, shall then declare the session adjourned for lack of quorum. Maraming nangyayari to sa barangay. So when I was still assigned in Hingoog City, kalaban nila si Kapitan. Ang nanalo si Kapitan at saka isang kagawad lang, silang dalawa lang mag-a-attend sa session. Kaya palaging pumupunta sa office, nagpapatulong kung paano nila ma-require. So I just give them the provisions of the law na ito yung pwede natin gawin. So nangyayari talaga ito. No? Okay. is the Vice Mayor included in the composition of the Sanggunian? The answer is a big yes. No? So meaning, di ba, si Vice Mayor, though he is a presiding officer, kasama siya doon sa composition ng Sanggunian. Which means, the Vice Mayor is included in the determination of a quorum. Kasi kasama siya doon sa organization ng Sanggunian. So, meaning, pag magbilang tayo ng members of the Sanggunian, included na dyan si Vice Mayor as member of the Sanggunian. Later, I will illustrate that. We have cases and we have illustration. I think nabasa nyo yung illustration. Yeah, this one. This La Carlota City Negros Oriental versus Attorney Rojo. Time check is 3:10, so may around 20 minutes pa lang ako natitira. Okay. So, in computing the quorum in the Sangguniang Panglungsod, this is the case of La Carlota City Negros Oriental versus Attorney Rojo. No? In computing the quorum in the Sangguniang Panglungsod, its entire membership must be taken account, including that of the city vice mayor or the presiding officer. Ito yung sinasabi ko, na in computing and in determining the number of legislative body, that particular Sanggunian, you have to include the vice mayor, the city vice mayor, the municipal vice mayor, or the vice mayor, the provincial vice mayor, no? The vice governor rather, the vice governor in the membership, no? And of course, must be taken into account doon sa pag-determine natin ng or pag-compute ng quorum. Now, the Vice Mayor as presiding officer is a member of the Sanggunian, considering that he is mandated under the code to vote to break a tie. So kung technically, kung titingnan natin, he is still a member of the Sanggunian. But, ito lang, may limitations lang. In fact, he can participate in the voting, but the limitation, he can only vote to break a tie. In a way, kung titingnan natin, technically nga, he is still a member of the Sanggunian. That's why kasama siya doon sa pag-compute ng quorum. A contrary ruling would create an anomalous and absurd situation where the presiding officer who votes to break a tie during a Sanggunian session is not considered a member of the Sanggunian. So medyo alanganin naman na boboto siya and yet he's not a member of the Sanggunian. So the ruling, based on this particular jurisprudence, kasama siya sa Sanggunian. Do you include the preventively suspended Sanggunian member in the determination of a quorum? Ito, importante din to. Kasi may mga cases na preventively suspended for, say, 3 months, no? Or 2 months, preventively suspended. Pagka na-suspended ba yung isang tao, isasama ba natin siya doon sa determination ng quorum? Of course, hindi na. Hindi na. Why? Because he is outside the coercive jurisdiction of the Sanggunian. His suspension constitutes a legal restriction for him to perform his powers, duties, and functions. Unlike kasi doon sa sinabi ko kanina na there is a coercive way ito, yung parang i-force mo talaga yung ibang mga sanggunian na hindi nag-attend for any valid reasons or parang justifiable cause, pwede mo silang i-coerce. But this time, or a force. But this time, hindi mo na pwede yung isang member kasi he is preventively suspended. So there is what we call as the legal restriction of the member to attend the session. So in that case, sabi ng DILG opinion natin ng 2006, no? Hindi mo na siya kailangan isama doon sa computation ng quorum. Okay? So iba to sa sitwasyon yung mga sanggunian na hindi lang talaga gustong mag-attend for no valid reasons. Okay? For no valid reasons. Now, what about the approval of ordinance? Parang ano na lang ito, no? Parang reading na lang ito, no? Every ordinance enacted by the Sangguniang Panlalawigan, Sangguniang Panglungsod, or Sangguniang Bayan shall be presented to the provincial governor or city or municipal mayor. No, the higher Sanggunian will review, no, the whatever ordinances that is approved by the lower Sanggunian. If the local chief executive concerned approves the same, no, ito pala before the review of the higher Sanggunian, the approval of the local chief executive muna tayo, no. Okay, so to be presented to yung mga, depende kung sa province, sa provincial governor, kung sa city naman, city mayor, and for the case of the municipal, it's municipal mayor. No? If the local chief executive concerned approves the same, he shall affix his signature on each and every page thereof. Otherwise, he shall veto. Remember that the mayors, starting the municipal mayors and the governor, no? The governors, na may tinatawag tayong veto power, no? He shall veto it and return the same with his objections to the sanggunian, which may proceed to reconsider the same. So kung aprobahan niya yon, kung okay sa kanya yung mga panukala na yun sa sanggunian, he has to affix his signature. But kung hindi naman, then magbe-veto siya and return the same, ibalik niya with his objections. Talagang in writing ito, no? Which may proceed to reconsider the same. Pag halimbawang i-veto naman ni Mayor yon, may remedy ang sanggunian kung talagang gusto talaga nilang ipasa yung isang ordinansa na yan. And the remedy is this. The sanggunian concerned may override the veto of the local chief executive by the 2/3 vote. So mas mataas-taas na boto ang kailangan nito. Of all its members, thereby making the ordinance or resolution effective for all legal intents and purposes. No? Kung mag-exercise ng veto si Mayor, that veto na ginawa ni Mayor, of course may objections, may reason siya bakit niya bineto yan, but it can be overridden. That veto by the local chief executive can be overridden by the 2/3 vote of all the members of the ordinance or resolution effective for all legal intents and purposes. So kahit wala ng approval si Mayor, pagka the ordinance was overridden by the 2/3 vote of all the members, then it will become effective for all legal intents and purposes. So parang sa ano lang din yan, parang sa president lang din ng republic na may veto power doon sa mga bills na pinasa ng Congress sa president. Ganun lang din yun. The veto shall be communicated by the local chief executive concerned to the sanggunian within 15 days in case of a province and 10 days in case of a city or municipality. Otherwise, the ordinance shall be deemed approved as if he had signed it. So take note of the prescriptive period or the reglementary period within which the sanggunian concerned has to affix his signature or to file a veto on that particular ordinance or resolution for that matter. Otherwise, pag mag-exceed na doon sa reglementary period, then that because of the inaction of the concerned local chief executive, that ordinance that was submitted in sa local chief executive, okay, pag maglampas na doon sa mga days na mention ko kanina, shall be deemed approved as if he had signed it. So deemed approved siya pag there is an inaction on the part of the local chief executive. Ordinances enacted by the sangguniang barangay shall, upon approval by the majority of all its members, be signed by the punong barangay. Ito kasi hindi na mention si punong barangay. Kasi si punong barangay, unlike the municipal mayor papuntang provincial governor, may veto power siya. Pero si punong barangay, wala siyang veto power. Why? Because remember that the punong barangay is at the same time the presiding officer. So bakit pa niya i-veto kung nandoon naman siya during the di ba? During the deliberation of the matter. And ito nga unique sa barangay kasi the punong barangay is at the same time hindi nga lang executive, legislative, yung ini-exercise ng punong barangay are the three branches of the government, the executive, the legislative, and even the judiciary kasi siya yung chairman ng katarungang pambarangay, ng katarungang pambarangay. So ganun ang kaibahan pagdating sa barangay na hindi pwedeng So si punong barangay ang gagawin niya diyan i-approve niya yan, once approved, isa-sign yan ng punong barangay. So we have now the validity of an ordinance, Yung sinasabi natin, kailan magiging approved or valid ang isang ordinances. Actually may dalawang kina-cluster to, Parang sinasabi natin may dalawang parts, Okay? there is this formal and the substantive. Nung sinasabi natin na formal na requirement for an ordinance to be valid, dapat within the corporate powers of the LGU to enact. So alam naman natin na we have the corporate powers of the LGUs to enter into contract, for example, to things like that, no? In the exercise of its corporate powers. Dapat within that scope lang, within that corporate powers of the LGU. Kasi pag lalampas doon din, that will not be considered valid ordinance. There is going to be, again, magiging ultra vires yan. That's beyond the authority of the sanggunian. And the other requirement, no, for an ordinance to be valid is that it passed according to the procedure prescribed by law. So kailangan sa isang ordinance, for example, no, tax parang tax fees and charges na ordinance, for example, dapat it has to go through with the process, no? Anong mga proseso nito? Of course, there should be a public hearing, there should be publication. Those are the procedural requirements that should be complied, no, before an ordinance will become a valid ordinance. That's under formal na requirements. Under naman sa substantive na requirement, this is accordingly, pag sinasabi nating substantive, the ordinance should be in consonance with certain well-established and basic principles of substantive nature. So for example, dito sa validity of an ordinance, yung sinasabi nating substantive nature, we have now the Supreme Court held that to be valid, an ordinance must conform to the following substantive requirements. Ito yung mga requirements para maging valid according to the Supreme Court. First, sinasabi dito, it must not contravene the Constitution or any statute. That's the first, no, requirement under substantive. Dapat hindi talaga siya lalampas. Second, it must not be unfair or oppressive. That ordinance. No. Third, it must not be partial or discriminatory. Fourth, it must not prohibit but may regulate trade. Fifth, it must be general and consistent with public policy. And lastly, it must not be unreasonable. So it should be reasonable. So those are the substantive requirements of an ordinance for it to become a valid ordinance. Now, in what ways may an ordinance be approved? There are three ways, no, na ma-approve yung ordinance natin. Signing by the LCE signifying approval thereto, or inaction, ano part yung sinabi ko kanina, no? Dalawang ano lang to. And the third one, ito yung overridden, i-veto ng LCA and it will be overridden by the sanggunian. Those are the three ways by which an ordinance may be approved. Okay? So, is the Vice Governor, Vice Mayor as presiding officer included in determining the majority vote? No, kanina, don't be confused ha, kasi kanina yung tinatanong natin, si Vice Mayor, Vice Governor, kasama ba siya doon sa computation ng quorum? Sinasabi natin, yes, because he is a member of the sanggunian. But ito sa tanong na to, is the Vice Governor, Vice Mayor as presiding officer included in determining the majority vote? Ang sagot natin is no. Because the Vice Governor, Vice Mayor as the presiding officer shall be considered a part of the sanggunian for purposes of ascertaining if a quorum exists. In determining the number which constitute as the majority vote, the Vice Governor is excluded, or the Vice Mayor. The Vice Governor, Vice Mayor's right to vote is merely contingent and arises only when there is a tie break. So dalawang scenario to, no? Kasama si Vice Mayor, Vice Governor sa determining or computing of a quorum, but hindi siya kasama sa pagdetermine sa majority, lalo na pagsasabihin natin pag magboboto na tayo, hindi dapat kasama si Vice Governor or si Vice Mayor, because the Vice Governor and the Vice Mayor under the law can only participate doon sa pagboto to break a tie. So, in other words, hindi siya dapat kasama sa pagboboto in the determination of the majority. Ito. Oo. Ito yung ano, perfect na example natin, no? The quorum and majority, no? Sa quorum naman, sa first itong column na to, you have to include, yung sinasabi ko sa iyo, sa quorum, you have to include the presiding officer, but in the computation of the majority, you exclude the presiding officer. So, the vice mayor, 1 is SB members, 8, 2 ito lang ha, hindi kasama, I think wala kay PMR dito. Ex officio members, siguro si SK at saka si Liga. So, a total of 11. So, sinasabi natin, pag quorum kasi is yung sinasabi natin more than half of a total. So, dito naman, the total is 11, right? 11. So 11 divided by 2, it's 5.5. Wala namang 5.5 na tao. So it should be 6 ang quorum natin. Okay? So 6 ang nagiging sagot natin dyan. Pagdating naman dito sa majority, ganun pa rin. 11 pa rin yung members, pero hindi mo isama si Vice Mayor. So nagiging, kung titingnan natin to, yung total member, yung total numbers ng majority na i-consider natin, 10 lang. So, 10 divided by 2, that's 5. So, majority, still 6. Okay? 6. So, pareho siya. So, assumption dito, all members are present. Okay. Dito naman, sa isang illustration, dapat maintindihan nyo to ha. Vice Mayor, SB members, 2 ex officio members, 8. Bakit nawala yung tatlong SB members dito? Kasi, absent sila with approved leave of absence. Sinasabi natin, pagka-approved leave of absence, kasama pa rin sila sa computation ng quorum. Kaya, kahit na 8 yung present that time, pero isama natin kasi itong tatlo, 11 pa rin. Di ba? Okay. Kasi hindi maa-affect yung number of members ng sanggunian by mere filing kahit na approved leave of absence. Yung sinasabi natin kanina na hindi isama pagka hindi qualified, hindi nag-qualify. No? Or yung sinasabi natin, yung may na suspended, hindi mo na isama yan. Pero kung nag-file lang ng absent or approved leave of absence, then kasama siya doon sa computation ng quorum. Same thing dito sa majority vote, no? 8 pa rin siya, pero ang assumptions 3 were absent, then small majority vote, majority of the members present there being a quorum, no? That's simple majority vote is 4. Okay? Why? Because they're present. Yung i-consider mo dito sa simple majority vote is that majority of the members present there being a quorum. So quorum pa rin siya kasi titingnan mo dito 8 naman, di ba? 8 pa rin kasi 6 lang naman ang kailangan mo for a quorum dito, di ba? Sa baba. So may total na 8, quorum pa rin siya, pero when you will compute yung small tawag dito, small majority, no? Simple majority, titingnan mo lang dito yung 5 at saka 2. Ito lang kasi yung present, di ba? 5 and 2, hindi mo na isama si Vice Mayor. So 5 plus 2, 7 divided by 2, that's 3.5. So sa simple majority is 4. I hope naintindihan yan. Okay. So, ano yung mga approval of ordinances na sinasabi natin? Wala na ba doon? Wala na example? Ito. Bakit nakaligtaan to? Okay. Dito naman, dito naman, Vice Mayor, 6 lang yung SB members, ex officio 2, 9 na total, no? 9 ang total. So ang assumption natin dito, 2 Sangguniang Bayan members were not proclaimed. So sinasabi natin pagka hindi siya na-proclaim, ano sinasabi natin? Hindi natin siya isama doon sa total number of members in that legislative body. So dito kasi kasama si Vice Mayor, 1 plus 6, 7 ex officio members, 2, 9. So 9 divided by 2 kasi hindi mo na isama to si 2 dito kasi nga they were not proclaimed. 9 divided by 2, that's 4.5. So kaya naging 5 kasi wala namang 4.5 na tao. Wala namang 0.5 na tao. Okay? So dito naman sa kabila, hindi tayo malito dalawang instances to. Kompleto lahat, may nag-file ng leave of absence, may hindi na-qualify. So ito naman sa hindi na-qualify, ganun pa rin yung application natin. Kailangan lang dito kasi, at ito naman ang assumption dito is 3 SB members were not proclaimed. So instead of 8, 8 lang sila. Andyan si Vice Mayor, andyan dyan yung 2 ex officio. So all in all, 8 sila. Pero kasi kung titingnan mo, kung i-determine mo yung majority vote, you will not include or you have to exclude the presiding officer. So 5 plus 2, that's 7. Yun lang talaga ang i-consider mo in determining the qualified majority vote. Divided by 2, that's 3.5, kaya nagiging 4 yung ano natin, qualified majority vote. So iba yung sinasabi natin qualified majority vote at saka sa simple majority vote at saka sa simple majority vote. So tatlong instances yun, no? The majority vote, the qualified majority vote, and the simple majority vote. I hope naintindihan natin yan. Okay, approval of ordinances. So ito yun, it's just an enumeration kung ano yung mga ordinances na i-approve, no? Ito ng sanggunian. Appointment of the department heads. Alam naman natin to, no? Napag-usapan na natin to before na yung mga department heads subject to the approval of the sanggunian. Levy of tax, fees and charges, tax exemptions, incentives or reliefs, talagang kailangan yan, no, ng approval of ordinances. Resolution giving authority to LCE to enter into contract or of loans and other forms of indebtedness. Although it is a form of resolution kasi, resolution authorizing, but it is really, the effect of that is an ordinance. Okay? Ordinance authorizing the flotation of bonds or yung mga PPP, public partner partnerships, flotation of bonds or other instruments of indebtedness. Kung mangungutang sa land bank, kailangan niya ng ordinance. Alam naman natin yan. Maraming mga LGUs na gumagawa niyan. Kailangan ng ordinance yan. Authority of the LCE to lease to private parties and public buildings. Okay. Tax exemption to community-inducing industries. These are the mga kailangan ng approval of ordinances. Granting of franchise on establishment, construction, operation, and maintenance of ferries, wards, markets, and slaughterhouses. Selection and transfer of local government sites, offices, and facilities. Permanent closure of roads. Pag-usapan na natin yan under Section 21. It requires an ordinance by the sanggunian concerned. Internal discipline of sanggunian members based on its internal rules. Kailangan din yan ng approval of an ordinance. Kasi magiging binding ito eh. Okay? And then overriding the veto, kailangan yan. It even requires more than the majority na vote. It's 2/3 vote. Transfer of LGC of okay. Classification of agricultural lands. Napag-usapan na natin yan. Contribution of funds, failed states, equipment, and other kinds of property, things like that. Levy on tax, fees, and charges on any base or subject not otherwise specifically enumerated in the local government or tax under National Internal Revenue Code or other applicable laws. Enactment of tax and revenue ordinances, of course, kailangan talaga yan. So ito yung Section 55, ito yung veto power of the local chief executive. The local chief executive may veto, nabanggit ko na ito, no? Any ordinance of the Sangguniang Panlalawigan, Sangguniang Panglungsod, or Sangguniang Bayan on the ground that it is ultra vires or prejudicial to the public welfare, stating its reasons therefore in writing. So ito lang yung magiging grounds ng local executive to veto the ordinance enacted by the Sanggunian. On the ground of ultra vires or beyond the authority of the Sanggunian or beyond the authority of the LGU, or that proposed ordinance is prejudicial to the public welfare, that of course it has to be stated in the yung written na veto niya doon sa yung pagbalik niya doon sa sanggunian. The local chief executive except the punong barangay shall have the power, ito sinabi ko na to, an ordinance or resolution adopting a local development plan and public investment program, or an ordinance directing the payment of money or creating liability. In such a case, the veto shall not affect the item or items which are not objected. So, hindi kailangan na yung buong ano yan doon sa public investment program, no, na ginagawa ngayon, okay, for approval ng local chief executive, okay, or the appropriation ordinance na gagawin ng mga sanggunian, hindi kailangan na i-veto niya yung lahat, kundi pwedeng maging item lang doon and it will not affect yung ibang items na hindi niya na veto. So that's the effect, no, doon sa pagveto doon sa appropriation ordinance and the public investment program. The local chief executive may veto an ordinance or resolution only once, no, once lang. The Sanggunian override the veto of the local chief executive concerned by 2/3 vote of all its members, thereby making an ordinance effective even without the approval of the local. Sabi ko na sa'yo sa to, no? Pag nabeto na niya and then it was overridden by the Sanggunian bayan or panlalawigan or panglungsod concerned, then hindi na yan pwedeng ibeto uli ng ating local chief executive. For all intents and purposes, it has a force and effect of a law. The grant of the veto power confers authority beyond the simple mechanical act of signing an ordinance or resolution as a requisite to its enforceability. The power accords the LCE the discretion to sustain a resolution or ordinance in the first instance or to veto it and return it. So ibalik talaga niya, no? Hindi na pwedeng hindi niya action na niyan kasi yung sinasabi natin kanina, the other way of approving an ordinance is the inaction of the local chief executive within the prescriptive period. Depending on the level of the Sanggunian. No? Return it with these objections to the Sanggunian, which may proceed to reconsider the same. What are the grounds to justify the veto of an ordinance or parts thereof? No? Ito yung sinasabi ko kanina. Ultra vires and parts thereof are prejudicial to the public welfare. Dalawang grounds lang. Walang ibang pwedeng grounds si Mayor or si Governor. Okay? Is written veto message required whenever the LCE requires this veto power? Of course, yes. No. For the LCE to validly exercise its veto power, the legislative measure subject of such veto should be returned to the Sanggunian concerned together with his written objections thereon, and clearly stating the reasons for the veto. What is the rationale of the veto message? No, this is for the Sanggunian. Bakit ibalik? No, bakit ibalik? At saka para naman ang Sanggunian to intelligently exercise its statutory power and prerogative to override the mayor's veto by a 2/3 vote of all its members, thereby making the ordinance or resolution effective for all intents and purposes. So that is why it has to be in writing yung pagbalik ng kaniyang o pagveto niya ng kaniyang proposed ordinance. Kasi pag-aralan niya ng Sanggunian kung i-override ba nila or hayaan na lang na hindi na talaga mapasa. Depende yan. But again, if they intend to really override the veto power, the veto of the LCE, then it requires a 2/3 vote of all its members. What is the legal effect when vetoed ordinance is overridden by the Sanggunian? Pabalik-balik na to, no? Is there a need for a vetoed ordinance to be calendared for first reading? There is no need, no? Diretso na yan. Upon receipt by the Sanggunian of the veto message, it may immediately calendar the same for deliberation, whereupon it may resolve to override the veto or adopt or introduce amendments to the vetoed ordinance to conform with the reasons of the veto. So hindi na kailangan, automatic yan. There is because of its urgency. Okay, 2/3 vote yan. What is the legal effect if the LC vetoes and items? So diyan the item in the appropriation ordinance of the previous year corresponding to the veto, if any, shall be deemed re-enacted. No? Pagka may veto siya na item doon, ibig sabihin hindi ma-implement yan. So kung hindi ma-implement yan, it should be the budget of the previous year. So it will be a re-enacted budget of that particular item vetoed by the local chief executive. Within 3 days after approval, the secretary to the Sangguniang Panglungsod or Sangguniang Bayan shall forward to the Sangguniang Panlalawigan for review copies of approved ordinances and resolutions approving the local development plans and public investment programs formulated by local development councils. So this is now the review power of the higher Sanggunians relative to the ordinances approved by the lower Sanggunian. So within 3 days dapat i-transmit doon sa higher Sanggunian, no? Depende. Within 30 days after the receipt of copies of such ordinances and resolutions, the Sangguniang Panlalawigan shall examine, no? Pagka ma-receive na nila yung galing sa municipality and component cities, within 30 days dapat action na nila yun, examine nila na yan, and then transmit them to the provincial attorney, no? Or if there is none, to the provincial prosecutor for prompt examination. The provincial attorney or provincial prosecutor shall, within a period of 10 days, from receipt of the documents, inform the Sangguniang Panlalawigan in writing of his comments or recommendations which may be considered by the Sangguniang Panlalawigan in making its decisions. If the Sangguniang Panlalawigan finds that such an ordinance or resolution is beyond the power conferred by the ultra vires, diba? That's the the ground for the higher sanggunian to disapprove or to not to approve the ordinance. No? It shall declare such ordinance or resolution invalid in whole or in part. The Sangguniang Panlalawigan shall enter its action in the minutes and shall advise the corresponding city or municipal authorities of the action it has taken. So it has to be transmitted whatever actions of the higher Sanggunian after reviewing yung mga ordinance na submit sa kanila, it has to be transmitted to the source, no, kung saan man galing yung ordinance na yon. For some actions that has to be taken. Okay, why no? The law grants the Sangguniang Panlalawigan the power to declare a municipal resolution invalid on the sole ground that it is beyond the power of Sangguniang Bayan. Okay, so kaya nga pagka ultra vires beyond the power, then the Sanggunian has the power to declare a municipal resolution invalid. Take note of the ground na beyond the power of Sangguniang Bayan. If no action has been taken by the Sangguniang Panlalawigan within 30 days after submission of such an ordinance or resolution, the same shall be presumed consistent with law and therefore valid. So, kung may pinasa doon sa higher Sangguniang Panlalawigan, for example, hindi na-actionan, then within 30 days, that is deemed approved again, no, for the inaction. Within 10 days after its enactment, the Sangguniang Barangay, in the case of the barangay, shall furnish of all barangay ordinances to the Sangguniang Panglungsod or Sangguniang Bayan, the immediate higher Sangguniang, for review as to whether the ordinance is consistent with law and city or municipal ordinances. So this is the review power of the Sangguniang Bayan and the Sangguniang Panglungsod over the ordinances enacted by the Sangguniang Barangays. If the Sangguniang Panglungsod or Sangguniang Bayan, as the case may be, fails to take action on barangay ordinances within 30 days from the receipt thereof, the same shall be deemed approved. No? Parang ganun din, no? What is the legal effect of an ordinance under review if not acted upon by the reviewing authority within the prescribed period? Ganun pa rin, deemed approved, no? Any attempt to enforce, ito yon, pagpilit talaga yung Sangguniang Bayan or Sangguniang Barangay na i-implement kahit na disapprove, this is the effect, no? Any attempt to enforce any ordinance or any resolution approving the local development plan and public investment program after the disapproval thereof shall be sufficient ground for the suspension or dismissal of the official or employee concerned. So may administrative case na ipafile kung sakaling pumili talaga sila kahit there was already a disapproval of their public investment program. Unless otherwise stated in the ordinance or the resolution approving the local development plan and public investment program, the same shall take effect after 10 days from the date a copy thereof is posted in a bulletin board at the entrance of the provincial capital or city, municipal or barangay hall, as the case may be, and it lasts, okay, the requirement in the posting. Okay, this is the posting. No? Ito lang siguro, I have to emphasize this. No? The general rule, after 10 days from the date a copy thereof is posted in a bulletin board, the entrance of at the entrance of the hall and in at least 2 other conspicuous places. Ito yung date of effectivity kasi nakalagay doon after 10 days from the date a copy thereof is posted in a bulletin board, no? So, note, after 10 days here refers to, for example, for an ordinance, shall take effect on the 11th day from date of posting. Okay? It's the 11th day from date of posting. Exception, unless otherwise stated in the ordinance, no? Yun talaga ang general rule, 10 days after its posting. Pero may exception kung halimbawa importante na talaga na ma-implement natin, it has to be provided in that particular ordinance na yung date of specific date or days within which the ordinance will become effective. The phrase unless otherwise stated in the ordinance means that the 10-day period may be lengthened or shortened by the Sanggunian. No? Take note of this. No? Unless otherwise stated in the ordinance means that the 10-day period, no, may be lengthened 10 days after the posting, di ba? May be lengthened or shortened by the Sanggunian. Now, the above exception is referred to the 10-day period and not that the requirement of posting. Now, remember that under the law, the civil code, no, of the Philippines, and even in the local government, posting really is a requirement. So, ang sinasabi ditong pwedeng i-shorten dito is hindi yung posting ng 10-day, yung posting of the ordinance, but yung 10-day after ng posting, yung pwedeng ma-shorten ng sanggunian. Hindi yung number of days na ipopost yung ordinance na yon. The posting requirement is mandated by due process. Yes, importante ito. Hindi pwedeng ibaliwala ito, or it has to be enacted, or may magkakaroon ng stipulation na i-waive itong posting. Kasi nga, this is part of the due process that the people will be informed of the ordinance, especially if it will affect them, no? Especially kung nakaka-apekto sa kanila talaga yun. Thus, the ordinance produces no effect until and unless it completes the posting requirement. So, hindi yan pwedeng pag-usapan or gawa ng stipulation doon sa ordinance na hindi na kailangan i-post yun, kasi that is a basic requirement. Before, sinasabi ko sa inyo kanina, di ba? That's a basic requirement under the formal requirement, wherein the hearing and posting of the ordinance is really a requirement before an ordinance will become a valid one. So hindi pwedeng ma-waive yan. Not later than 5 days after approval, the barangay secretary shall post the ordinance. Filipino or English, or mas maganda yung maintindihan sa lahat. What if the ordinance states that it shall take effect immediately? May mga ganun eh. It shall take effect immediately. The ordinance shall take effect immediately after the posting. Ibig sabihin, kung kailan matatapos yung posting, that is the effectivity of the ordinance. The 10-day period after posting is dispensed with, but not the posting requirement being mandated by due process. So, ang sinasabi kasi natin dito, yung 10-day period na sinaposting is dispensed with, yung pagkatapos ng posting na yun, yung 10-day period yun yung dinispense natin. Na pagkatapos ng posting, wala ng counting of the 10-day period, but nagiging effective na siya on the day after na-comply na yung requirement on posting. What if the ordinance states that it shall take effect upon approval? The phrase unless otherwise stated in the ordinance is referred to the date of effectivity and not the posting requirement itself, which cannot be in any way, in any event, be dispensed with. So it's really a formal requirement, kasi pagka hindi ito ma-post, hindi mag-comply sa requirement on posting, then that ordinance is considered null and void. Okay? It has to be inoperative or ineffective. The phrase does not mean that the sanggunian may take the ordinance effective immediately upon approval or on any other date without its previous posting. Posting is an indispensable requirement, but the sanggunian may, in its discretion, provide that the usual 10-day period shall be shortened or extended. 10-day period after the posting, not the posting itself. If the ordinance has no particular date for its effectivity, it will not take effect upon its approval, notwithstanding its express statement in the ordinance. Hence, the general rule will apply. It will still take effect after 10 days from its posting. That's the general rule. No? 10 days after the posting requirement. Okay, so that will be all for the first topic. Kunti na lang to, Kuya Pat, are you there na? Saglit na lang ito for the internal discipline of sanggunian for a moment, please.
Yes, Pabs. Okay. Pabs. Didi June.
I have to fix my next presentation first, Kuya Pat. Thank you.
Sige. Okay.
Okay, actually na-discuss ko na to, but for purposes of the presentation na ginawa naman na itong visual aid, I have to take this up. No? The internal discipline of Sangguniang members. As I mentioned earlier, itong discipline of Sangguniang members should be provided. No? Nakapaloob ito sa sinasabi natin internal rules of procedure. Okay? Yung sinasabi natin yung decorum ng mga kasamahan doon sa legislative body. So, saglit lang kasi hindi na bumove yung presentation. Okay, back. No. For the internal discipline mechanism, there are only two grounds, no? Wala pa rin. Okay, these are the grounds for disciplining the members of the Sanggunian. First is disorderly behavior, and the second one is absences without justifiable cause for 4 consecutive sessions. Take note of the word 4 consecutive sessions. Dapat magkasunod-sunod talaga yan, no? And notably dito, the grounds are exclusive. No? They are exclusive. Talagang hindi pwedeng magkakaroon ng ibang grounds other than those that are mentioned here, no? ng Section 50. Okay. So, under paragraph B, no, of RA Section 50, RA 7160, a Sangguniang member may only be disciplined by the Sangguniang concerned through its disciplinary mechanism, internal disciplinary mechanism on either of the two grounds. Dalawa lang talaga, yun yung nabanggit ko. The Sangguniang cannot expand the grounds for or include other grounds as basis for disciplining its members. We have actually a DILG opinion 83 series of 2004 for that particular provision. Now, actions done outside the session not covered by IDM. What is the effect now? The acts constituting the grounds must be committed in the relation to, on occasion of, or during session. So kailangan nandun lang talaga. That was during the deliberation. Acts committed outside the session or not related to the session of the Sanggunian cannot be the subject of internal disciplinary action that can be imposed by the Sanggunian. I already mentioned this earlier. No? Pasadahan na lang natin ito. The Sanggunian, breach of internal discipline, not ground for dismissal. Kaya sinasabi ko sa inyo, the Sangguniang Bayan has no authority to dismiss a member of the Sanggunian. Kasi ang pwede lang nilang pinaka matinding sanction na pwede nilang maipataw sa kasamahan nila if ever there is a breach of internal discipline, yung suspension lang talaga, not more than 6 months. But for in the case of expulsion, expel nila or tanggalin nila sa roster ng Sanggunian, that is not within the authority of the Sanggunian. That is now the authority of the proper court or the regular court. And in that case, it is the regional trial court. The Sanggunian cannot dismiss a colleague for breach of internal discipline. Dismissal is not one of the sanctions provided for by the code. The only allowable disciplinary sanctions provided by the local government code are suspension and expulsion. Di ba binanggit ko na to kanina, expulsion is different from yung i-expel. Expel mo yung member. Expulsion dito, ang sinasabi as understood in this provision, pertains only to the removal or expulsion of a member for that particular session for disorderly behavior. Iba naman yung sa expel mo talaga siya sa membership ng sanggunian pagka may final judgment siya of 1 year, no? Final judgment of 1 year, and then the crime was moral turpitude, di ba? So iba yon, talagang tanggal yon sa roster ng sanggunian if there is a finality of judgment. So requisites for automatic expulsion in review of conviction by final judgment. So the requisites, offender must have been convicted by, ito yan, pagka expulsion in view of conviction, ito yung sinasabi ko. Offender must have been convicted by final judgment to imprisonment for at least 1 year, and the conviction should be for a crime involving moral turpitude. Okay, so that would be all. Any questions before? I think I can only accommodate 1 or 2 questions before we can proceed with the next topic by Director Patrick. May gustong magtanong? Going once, twice, thrice. Okay. So I hope naintindihan naman yun kahit na medyo mabilis yung presentation ko ngayon kasi nga medyo sumobra na nga ako sa oras. Hope Kuya Pat could manage his time lalo na medyo lumampas ako. Okay. So Director Patrick, are you ready now to present your last 2 topics, I think?
Yes, PD Jun.
Okay. Thank you very much. Thank you very much and good luck sa exam nyo mamaya. And later siguro matatapos kung ma-check yung papers so with your reflection. So hopefully tomorrow ma-post ko na. Thank you very much and good luck sa Kuya Pat, thank you very much.
Thank you po.
Thank you po. Palakpakan natin via virtual cup si PD Jun. Palakpakan natin. Actually, this is the last synchronous session natin. Yung mga succeeding sessions natin would be mere discussion of the quiz results. No? So ito na yung last session for coaching or synchronous session. Okay, so natakel na yung local legislation and the IRP. No? Tomorrow, meron kayong related session with Attorney Moreno, yung ating dating ASEC and Director ng Legal Service ng ating DILC. So, itatakal na yung parliamentary procedures. Okay, so for my session, share ko lang yung screen. Okay, nakikita nyo na yung screen?
Yes po, Coach.
Okay, so my topic is about venues for people's participation. Yung governance, yung local governance is not solely for the government only. No? Meron ding access or venues ang ating mga citizens para mag-participate sa local governance and establish a clean and honest government. So, nakapaloob po ito sa ating local government code, Republic Act number 7160 at iba pang mga related laws. So ano-ano ba itong mga venues for people's participation? No? Unang-una, prior mandatory consultation. Pangalawa, through the participation or membership in the local special bodies. Pangatlo, yung power of recall. No? Pwedeng magtanggal ng isang local official. And then, initiative and referendum, partnership and assistance with people's organizations and non-governmental organizations, barangay assembly, and sectoral representation in the Sanggunian. I think yung last, yung sectoral representation, natakel ko na to previously, no? So hindi ko na to itatakel. Anyway, Mga 1 oras na lang tayo. Cap Dennis, pwede mo akong paki-prompt yung last 10 minutes siguro before 5 para so that I can manage and wrap up siguro.
Okay po, Coach. Copy po.
Okay. Okay, ano ba yung prior mandatory consultation? No? Ito yung nakapaloob sa section 26 and 27 ng ating LGC. So, dito, dinefine ng Supreme Court kung ano yung mga national projects. No? Merong mga national projects na kailangan i-implement sa local. So, kailangan kapag ang isang programa ay may cause the following, no? Kailangan ng prior mandatory consultation. Unang-una, kung magdudulot ito ng pollution. No? Pangalawa, yung climate change, no? Yung greenhouse gas emission, talagang matindi. Pangatlo, yung depletion of non-renewable resources. No? Ano ba yung mga non-renewable resources natin? Ito yung mga fossil fuels, no? Yung natural gas, yung coal, no? And fourth, yung loss of cropland, rangeland, or forest cover. Kapag pero project at marami kang punong kahoy na aalisin o tatanggalin. Then next, yung eradicate certain animal or plant species. No? Lalong-lalo na yung mga rare species. And then yung kung merong mga madi-displace na group of people sa isang locality, no? Maiibig sila as a result of the project. No? So yun, kailangan ng mandatory consultation. So meron lang 2 requisites sa batas para ma-meet ang na masasabi na meron talagang prior mandatory consultation. So, 2 requisites must be met before a national project that affects the environment and ecological balance of local communities can be implemented. Unang-una, yung actual, yung prior consultation talaga with the affected local communities. So, merong mag-invite ka ng mga NGOs doon, mga citizens, mga affected, at pag-uusapan ano ba yung idudulot ng proyektong ito, ano ba yung magiging impact. No? So, i-document yun. And then pangalawa, after the consultation, as a result of that consultation, kailangan merong prior approval of the project by the appropriate sanggunian through a resolution. So of course, yung mga sanggunian members natin, consider din kung ano yung resulta ng consultation. So absent either of these mandatory requirements, masasabing illegal yung project. Okay, another note is that the requirement of prior consultation and approval applies only to national programs and or projects which are to be implemented in the local community. So dito sa case ni Lina versus Pano, yung Lotto hindi considered as a national project. So there's no need for a mandatory consultation. Okay. The local government code establishes the duties of national government agencies in the maintenance of ecological balance and requires them to secure prior public consultation and approval. And ito yung kaso, the lack of prior public consultation and approval is not corrected by the subsequent endorsement of the reclamation project by the sanggunian. Kasi dito sa kaso ito, merong reclamation project. Noong una, kinokontra ito ng barangay at munisipyo ng Malay. No? Pero later on, at the urging of the province, no? Nagpasa pa sila ng resolution. So kulang ang requirement dito. Resolution lang, wala siyang mandatory consultation dun sa affected communities. Okay, so dadako na tayo sa local special bodies. Kung merong clarification, you may interrupt me. Wala na time. Siguro mas mabilis pa ako kay PD Pops. So ito na yung mga local special bodies na kung saan pwedeng mag-member ng ating mga non-governmental organizations, no? Or people's organizations. So pwede sa LDC, sa local school board, local health board, sa Northern Council, sa PLEB, and the noon tinatawag na local qualification bids and awards committee. Pero ngayon, due to the passage of RA 9184, yung Government Procurement Act, back na lang, no? Bids and awards committee. Ayan. So unang-una yung Local Development Council. No? Ito yung composition. Siguro kabisado nyo na to. Yung representative of the NGOs operating in the LGU shall constitute not less than 1/4 of the members of the council. No? Not less than. No? Pero pwedeng more than. Okay, ito yung computation. Paano ka mag-come up ng NGO representation sa Local Development Council. Example, yung si Mayor 1, tapos yung konsihal, no, Committee on Appropriation, sa congressman or his representative sa all punong barangays. In this example, 21 barangays. So yung 3/4 nun, yung 75% of the full council is equivalent to 24. So to compute the number of NGOs, yung 24, i-divide mo lang ng 0.75. So mag-come up ka ng 32. And then you subtract 32 with 24. Yung 8, yun yung minimum NGO representation in the Local Development Council. So functions, hindi ko na siguro babasahin isa-isa ito. Pwede nyo na mabasahin ito sa LGC ninyo. Yung composition ng executive committee, no? Yung LDC kasi maraming members, no? Sometimes merong mga activities o decisions na dapat dapat mabilis ang madesisyonan. So merong in-create na executive committee. So ito yung mga composition niya. So meron pa ring representative ang ating mga NGOs. So ito yung function nila, ensure that the decision of the council are faithfully carried out and implemented. Pangalawa, yung act on matters requiring immediate attention. Kailangan talaga, or action by the council. Formulate policies, plans, and programs based on the general principles laid down by the council and act on other matters that may be authorized by the council. So, with the full permission of the council. Ano ba yung relation of LDCs? Itong mga PPAs na proposed by the LDCs shall be submitted to the sangguniang concern of the LGU. And then, the approved development plans of the LGUs shall be submitted to the RDC, Regional Development Council, which shall integrate into the National Regional Development Plan for submission to NEDA. Sa NCR, since wala naman kami mga provinces, ang nag-a-act na RDC, yung Metro Manila Council, composed of the mayors, under ito yung policy making board ng MMDA. So Metro Manila Council lang sa NCR. Sa ARM naman, yung Regional Development Planning and Development Board, based on RA 6734. Sa ARM. Sa BARM pala. Sorry. Okay, aside from the local government code, nag-issue tayo ng DILG-MC 2019-72. No? Ito yung guidelines natin in the accreditation of CSOs, no? For membership sa ating mga LSPs. Well, nilip ko lang ito na related. In no case shall an organization or a representative thereof be a member of more than one local special body within an LGU. So kailangan na pipili lang siya ng isang local special body. Hindi pwedeng lahat ng LSPs natin sila. And then, pangalawa, yung membership in the Local Development Council must have representatives from the women's sector. Parang dinitalye na nila ng ating MC. Representative from the women sector, or as may be practicable, at least 40% of the fully organized council shall be composed of women, as prescribed sa RA 9710 or Magna Carta of Women. And then pangatlo, yung representatives of NGO operating in the barangay, municipality, city, or province, as the case may be, shall constitute yung sinabi ko kanina, no? Not less than 1/4, but may be increased to 1/2 of the fully organized council to further expand citizen participation. So yan yung nandun sa MC natin. Okay, next local special body, yung local school board. Ito yung representing composition dun sa mga dito, mayor, tapos co-chair na yung district supervisor sa municipality. And then yung education committee ng Sangguniang, treasurer, representative ng lahat ng LGU, representative lang ng federasyon ng mga Sangguniang Kabataan. It's not automatic na yung federation president. And then yung president ng Federation of Parent Teachers Association, yung PTA. Tapos yung representative. Yung kanina yung president ng PTA, dito representative lang ng teachers organizations. And then yung representative of non-academic personnel of public schools. So ito yung functions ng LSB, Local School Board, determine the annual supplementary budgetary needs for the operation and maintenance of public schools and the supplementary local cost of meeting such things, which shall be reflected in the form of an annual school board budget. Merong budget ng LSBs natin, yung special education fund, no? Equivalent to 1% of the assessed real property. This is in addition to the RPT. Kumukolekta pa tayo ang LGU ng 1% of the assessed real property. So yun yung funds na pwedeng gamitin ng ating local school board. Then again, yung authorize the treasurer to disperse funds from the SCF pursuant to the budget prepared. Meron dapat budget. Mga programs, projects, and activities. Advisory committee to the Sangguniang on educational matters. Tapos recommend changes in the names of public schools within the territorial jurisdiction. Okay, next yung local health board. Ito yung composition. Merong representative ang mga NGOs na dapat nakalagay dun sa MC natin. Yung magme-member ng NGO is yung competencies ng mga members is health related. Tapos meron ding representative ang DOH. So ito yung functions. The proposed to the Sangguniang concern, in accordance with the standards of DOH, annual budgetary allocations. So meron silang say sa annual plan related to the operation and maintenance of the health facilities and services. Then advisory committee to Sangguniang on health, create committees that will advise local health agencies in personnel selection and promotion, bids and awards, grievance and complaints, discipline, budget review, operations review, and similar functions. Okay, sa Peace and Order Council natin, wherein the ILG is the secretariat. Ito yung composition. Hindi ko na basahin isa-isa. Dito lang sa 3 members of the existing kabarangay, 3 members of the existing barangay-based anti-crime or neighborhood watch group or NGO. And also the PNP officer. Tapos sa municipal, city, and province, 3 representatives from the private sector upon consultation with the members of the council. And kailangan may security clearances, no? Yung representative. No? Kasi merong confidentiality yung dinidiscuss sa POC, merong mga intelligence. No? So kailangan merong mga clearances. Doon sa province, aside from the consultation with the members, meron ding approval dapat ng commander of the infantry division and the RD ng PNP, regional director. Doon sa pagiging secretariat natin, pwede rin tayong tulungan ng LGU. No? Pwede tayong bigyan din ng staff. Okay, functions, hindi ko na babasahin ito isa-isa. Andyan yung PAPS plan. Ano pa. Ito lang, note, release and use of the confidential funds shall be covered by a resolution duly approved by 2/3 of the total membership of the POC. So, may POC resolution yan approving the allocation of confidential funds. Okay, ito yung functions natin, provide technical assistance. Sa POC, recommend tayo rin naman nagre-prepare ng agenda, no, in consultation with the LGU. And documentation, yung minutes ng meeting. Pati na yung kung ano man yung resolutions na papasa ng council. And prepare and submit semestral POC accomplishment report to the national POC through the RPOC. And then prepare and submit quarterly secretariat accomplishment report. Okay, so hindi ko na o meron din tayong People's Law Enforcement Board. Ito yung PLEB, tinatawag, no? Na siyang shall be the central receiving entity for any citizen's complaint against the officers and members of the PNP. So dito dinudulog yung mga complaint ng mga citizens against sa ating kapulisan, members ng ating kapulisan. Okay, kailangan merong PLEB in every 500 city or municipal police personnel, supposed to be. No? Or for any legislative district in a city. So, well, in practice, hindi due to financial constraints siguro, hindi masyadong nasusunod ito. Usually, one LGU lang, for one PLEB lang for every LGU, lalong-lalo na sa mga munisipyo, no, sa province. Pero pa rin naman, sumusunod, lalong-lalo na dito sa NCR, may budget naman. Bawat district merong PLEB. No? Pero meron pa rin LGU. Galing ako Marikina, hindi ito nasunod. Isa lang ang PLEB namin doon, pero dalawang district. Okay, ano ba yung compensation benefits ng isang PLEB member? Although civic duty, supposed to be yung pagiging PLEB. Hello? Naririnig pa ba ako?
Yes, coach.
Yes po.
Okay.
Yes, coach.
Yes, coach.
Okay, Okay, so pleb members shall be paid per diem and shall be provided with life insurance coverage as may be determined by the city or municipal council from city or municipal funds. Pero dito, sa pakalawang paragraph, DILG ang magbibigay. No? Para kontra. Pero in practice, hindi ito ginagawa. No? Wala tayong budget to provide for the per diem and insurance coverage. Especially with members. Sa city yung nasa unang paragraph dito sa low-income municipalities. Ewan ko sa inyo, sa mga munisipyo nyo, kung 5 and 6 class municipality yung assignment, kung nagbibigay ba kayo ng per diem and insurance coverage?
Yes po, Coach.
Meron
Dito
po, Coach.
Sa Batangas.
Dito rin po sa Quezon.
Okay, composition of pleb, unang-una, yung isang member ng sangguniang panglungsod or bayan chosen by the respective sanggunian. It's not automatic na yung committee chair on peace and order and public safety, siya yung magiging member. No? Pipiliin ng sanggunian kung sino. It's not automatic na yung committee chair ng peace and order. Pangalawa, punong barangay of the city municipality concerned chosen by the liga ng barangay. So, ganun din, hindi automatic na liga president. Siya yung magre-represent sa liga, sa pleb. Ipiliin din ng liga ng barangay. And 3 other members who can be removed only for posts chosen by the city or municipal peace and order council from among the members of the community known for their probity and integrity. No? Unang-una, one of whom must be a woman. Another, a member of the bar. Pero kung wala, pwede naman college graduate lang. And for the principal of the Central Elementary School in the locality. So 3 members from the citizens. And then ma-elect yung chairman from among its members. Sila mismo i-elect nila. Walang automatic chairman yung pleb. Merong election. The functions of pleb empowers the people against abusive and erring policemen. It has the power to hear and adjudicate all citizens' complaints formally filed with or referred to it against any uniformed member of the PNP, and if warranted, impose a corresponding penalty. Para rin silang judge. Pwede silang mag-impose ng penalty. Okay, the power of recall. Okay, ano ba yung recall is? It is a mode of removal of public officer by the people before the end of his term of office. It is an incident of their sovereign power and is in the absence of constitutional restraint. The power is implied in all governmental functions. So, merong loss of confidence, so ground siya for recall. In this case, Garcia versus Comelec, si Governor Garcia ng Bataan, ni-recall, nag-initiate ng recall proceedings against. So, unang-unang step, yung preparatory recall assembly in every LGU, composed sa provincial level, yung all mayors, vice mayors, and sanggunian members of the municipalities and component cities. Sa city level naman, lahat ng punong barangay and sangguniang barangay members. In a legislative district level, sa mga sangguniang panlalawigan, members are elected by district, yung mga board member. Ang composition ng PRA, yung all elective municipal officials in the district. In cases naman where sangguniang panglungsod members are elected by district, all elective barangay officials in the district. The district lang yan. Sa municipal level, all punong barangays and sangguniang barangay members. So a majority of all the preparatory recall assembly members may convene in session in a public place and initiate a recall proceeding against any elected official in the government, local government unit. recall of provincial, city, or municipal officials will be validly initiated through a resolution adopted by a majority of all the members of the PRA concerned during its session called for the purpose. So merong output, no? Isang resolution calling for the recall of a particular local government official. Then recall of any elected provincial, city, municipal, or barangay official may be validly initiated upon petition of at least 25% of the total number of registered voters in the LGU concerned during the election, which in the local official sought to be recalled was elected. So 25% pwede na mag-initiate. Pero ano yan, gathering of signatures. So 25% of the total number of registered voters na bumoto during the election na kung saan na-elect yung local official na nire-recall. Okay, so ito yung percentage requirement, voting population requirement. Dun sa requirement na at least 25%, ang population requirement not more than 20,000. Sa 20%, at least 20,000 but not more than 75,000 registered voters. Sa at least 15, at least 75,000 but not more than 300,000. Sa 10, over 300,000. Provided, however, that in no case should the required petitioners be less than 45,000. Okay, election recall. Upon the filing of a valid resolution petition with the COMELEC, local COMELEC, the commission or its duly authorized representative shall set the date of the election on recall. Ang COMELEC ang mag-set ng date, which shall not be later than 30 days after the filing of the resolution or petition. In the case of the barangay, city, or municipal officials, 45 days naman sa provincial officials. The official or officials sought to be recalled shall automatically be considered as duly registered candidate or candidates to the pertinent positions and shall be entitled to be voted upon. So, yung nire-recall, automatic kandidato, hindi pwedeng mag-resign. Okay, ito yung limitations ng recall boundaries. No recall shall take place within 1 year from the date of the official's assumption to office or 1 year immediately preceding a regular local election. Dito, merong jurisprudence. Yung tinutukoy dito na 1-year ban, yung recall election. So yung mga preliminaries na gagawin, yung initiation of organization of PRA, initiation, petition, pwedeng mangyari within 1 year. As long as yung recall election ay mangyayari after the 1-year ban. Dito naman sa 1 year immediately preceding a regular local election, yung susunod na election, kailangan, halimbawa kung municipal official yung nire-recall, yung preceding regular local election, kung municipal elections or kung municipal positions yung pagbobotohan sa susunod na election, yun ang hindi pwede. Pero kung SK election or barangay election, pwede. So ito yun pala. The 1-year ban refers to the election where the office held by the local officials sought to be recalled shall be contested. Yung 1-year ban, yun nga, kung municipal mayor, applicable yung ban kung ang susunod na election is about municipal officials. So dito, the scheduled barangay election is not the regular election contemplated for purposes of computing the 1-year prohibition for recall of municipal elective officials. Dahil ang nire-recall, municipal elective official, kaya ang susunod na election naman is barangay election. So hindi applicable dito yung 1-year ban. So ito yung sinasabi ko kanina. No? The 1-year ban cannot be deemed to apply to the entire recall proceedings. Yung limitations apply only to the power of recall which is vested in the registered voters, yung pagboto o yung recall election. So as long as the election is held outside the 1-year period from assumption to office of the local officials sought to be recalled, the preliminary proceedings to initiate the recall can be held even before the end of the first year in office of the said local official. So it's under the Claudio versus Coke elective. Another boundaries of recall, officials sought to be recalled shall not be allowed to resign. Hindi pwede mag-resign. Automatic candidate siya. Official may be the subject of recall election only once during his term. Isang beses lang siya pwedeng i-recall. So ito yung sinasabi ko, yung recall na nandun sa LGC refers to the recall election and not to the preliminary proceedings. So ito na-explain ko na. So dito, yung regular local election na sinasabi yung sa provision refers to the date of such election. Yung election day mismo, and it does not include yung election period, no? Yung before election. Which includes yung campaign period. Election date. Effectivity ng recall is only upon the election and proclamation of a successor in the person of the candidate receiving the highest number of votes cast during the recall election. So yung nire-recall na official can either lose the recall election or pwede rin siyang ma-re-elect. So, ibig sabihin ito, pag na-elect siya, confidence in him is thereby affirmed and he shall continue in office. Okay, sa initiative and referendum naman, iba naman to from recall. Doon sa recall, tao yung pinag-bobotohan. Dito, it's either a resolution or an ordinance. So yung local initiative is resorted to or initiated by the people directly, either because the lawmaking body fails or refuses to enact the law, ordinances, resolution, or act that they desire, or because they want to amend or modify one already existing. So, halimbawa, mayroong proposition ang mga citizens, no? I think within 30 days, kung walang action yung sanggunian, hindi nila tinakil or they refuse to tackle it or enact, pwedeng mag-initiate, mag-local initiative ang mga citizens. Yung local referendum naman, ito yung pagbobotohan na kung approve or reject yung isang proposed ordinance or resolution that was na pinroposed sa local initiative. Ito yung election na. The lawmaking body submits to the registered voters of its territorial jurisdiction for approval or rejection any ordinance or resolution which is duly enacted or approved by such lawmaking authority. So sa referendum, yes or no lang yun. The application of local initiative extends to all subjects or matters which are within the legal powers of the Sanggunian, meaning ordinances and resolution. Yun lang dalawang yun, ordinances and resolution lang. Ito yung procedure sa local initiative. Not less than 1,000 registered voters in the case of provinces and cities. 100 in case of municipalities, and 50 in case of barangays na pwedeng mag-file ng petition with the sangguniang concern. Second, if no favorable action is taken by the sangguniang concern within 30 days from its presentation, the proponents, through their fully authorized and registered representatives, may invoke their power of initiative, giving notice to the sangguniang concern. So the proposition, numbered serially, and then dito, COMELEC ang COMELEC or its designated representative shall extend assistance. Sila yung punong abala rito.
Sige.
Okay, procedure. Sa local initiative, pwedeng 2 or more propositions, pero same subject matter dapat para hindi malito yung mga tao. Proponents shall have 90 days in case of provinces and cities, 60 days in case of municipalities, and 30 days sa barangay from notice to collect the required number of signatories to this requirement. And then the petition shall be signed by the election registrar in the presence of the representative of the proponent and representative of the sanggunian. Parang witness sila sa mga signature pag-sign. Stations for collecting signatures may be established in as many places. Upon the lapse of the period, the COMELEC, sila yung magse-certify kung nakamit man yung number of signatures. Pero kung kulang yung required signature, defeated yung proposition. Wala nang referendum na mangyayari. Kung na-obtain naman yung number of signature, isa-set na yung date during which the proposition shall be submitted to the registered voters. Yung referendum na within 60 days from the date of certification. Okay, ito yung mga limitations ng local initiative. It shall not be exercised more than once a year. And initiative shall extend only to subject or matters which are within the legal powers of the sanggunian to enact. Yun nga, yung ordinances and resolution. If at any time before the initiative is held, the sanggunian concerned adopts in toto. In-adapt naman nung sanggunian in toto yung proposition, wala nang initiative na nangyayari. Pero kung meron din po kontra dun sa proposition na nun, sila naman ang mag-initiate ng initiative. Kontra sila. Okay, so yung referendum shall be held under the control of the COMELEC within 60 days in the case of provinces and cities, 45 sa municipalities, 30 days sa barangay. And COMELEC shall certify and proclaim the results of the recent referendum. Pero tanong, sino ba ang gagastos sa referendum? Sa mga previous referendum na nangyari, COMELEC ang printing of ballots, mga paraphernalias, so sila talaga. Okay, partnership and assistance. Okay, nasa section 34 ito ng ating local government code. Kung saan the LGU shall promote the establishment and operation of people's and non-governmental organizations to become active partners in the pursuit of local autonomy. So ito yung definition ng POs and NGOs. Actually, when I was still with LGA, I was in charge with a program called B2B Pipeline. During the time of President Noynoy Aquino, ang daming NGOs na involved. So yun ang facility namin to get the NGOs involved talaga. Pero on the part of the LGU, nahirapan kami kasi parang ang tingin nila sa LGU, parang watchdog, parang tinitingnan yung mga butas o ginagawa ng LGU. So, parang critic ang tingin sa kanila. So through that facility, through that program na-enhance namin yung relationship, no? Merong effective partnership. I just don't know kung na-sustain yung ganung harmonious relationship. I hope. Because POs and NGOs are considered active partners. They are partners, no? Although sometimes critical collaborators. Parang gano'n ang role. Okay, ito yung case ng mag-task price. Discuss ko na ito. In contrast sa PAGCOR. And meron tayong mga PPP, di ba? Yung public-private partnership. So, allowed under the local government code for the LGU to enter into joint ventures in the delivery of basic services, capacity building, development of local enterprises, and assistance, financial or otherwise, may be provided to POs and POs, allowed through the LC and with concurrence of the Sangguniang. So yung collaboration could be in economic development, social development, environmental, or cultural projects. Okay, sectoral representation, natakal ko na to. Hindi na-include sa PowerPoint yung barangay assembly. No? So nakalagay naman siya sa local government code, first Saturday of March or October or second Sunday. Nandun. No? Although na-amend na ito ng Proclamation number 599, na kung saan pwedeng pumili ang barangay either any Saturday or Sunday ng October or March or October. Pwedeng mag-conduct ng barangay assembly. And dito, nagkakaroon ng state of the barangay address, no? Nire-report yung accomplishments, peace and orders, environment, health, lalo-lalo na in the past barangay assemblies, naging main focus yung COVID response natin, anti-drugs. So, yun. And yung financial report ng barangay. So, yun yung tinatakel sa barangay assembly. And tayo naman sa DILG, minomonitor natin ito. And as part of our duty, binabasa natin yung message ni Secretary in every barangay assembly. So, akala ko kukulain ako sa oras. So, itong sectoral representation, natakil mo ito. Hindi na natin ito natakil. May clarification ba or questions? Or masyado pang mabilis? So it's 15 minutes before 5. No, may time pa kayo to prepare for the quiz. Good luck. And as I've said, this is the last synchronous session natin. The next topics would be plenary, no? Parliamentary procedures, tapos yung budgeting, and the pitfalls. So kung walang questions or clarifications,
Coach Pat.
hello, Daryl? Meron?
Yes, Coach.
Yes.
Baka hindi ako makatulog, Coach. Linawin ko lang, Coach, yung sa kung kasama si Vice Mayor sa determination number of majority votes required. Kasi mayroong mga past legal opinions na sinasabing kasama si Vice Mayor. Pero yung mga recent lang, mga 2019 isa, hindi na siya kasama.
Ano ito? Tungkol sa?
Doon, Coach, sa determination of number of majority votes required.
Majority votes required sa?
Determination po ng majority votes.
Sa local leg ka na? Local leg ba to?
yung kanina coach diniscuss niya ni coach Fonz.
May I interrupt, Director Patrick?
Okay, sige. Sige, PT.
What's your query about?
Yung sa ano lang sir, determination of number of majority votes required ng sanggunian. So kung kasama si Vice Mayor dun sa
Hindi. Kasama lang siya in the computation of the quorum, pero pagdating kasi sa majority vote, kung kailangan boboto na sila, hindi siya dapat kasama kasi nga he's the presiding officer.
Okay, sir.
Oo.
Kasi may
Kasama
nakita
lang
sa
siya doon.
may nakita lang akong coach na mga legal opinion na sinasabing kasama siya. Pero yung mga recent naman ay iba na. Sinasabing hindi na siya kasama.
Can you just give us your basis kasi insofar as the material is concerned, yun yung pinaka recent na ginamit ni Attorney Ian. Oo. Na yung
Okay,
computation ng quorum. Can you
Sige po.
give us your basis?
I-send ko lang sir sa ano po.
Sure.
Sa LMS na.
Basta sigurado tayo doon kaya doon sa illustration na yon, kasama sa determination, 'di ba? Dalawang column yun, may determination yung sa quorum at saka doon sa simple majority at saka qualified majority. So pagka qualified majority or simple majority or the majority exclusive, hindi kasama excluded rather si Vice Mayor, Vice Governor. But in the computation of the quorum, no, para makapag-transact sila legally ng isang business, then kasama si Vice Mayor and Vice Governor kasi kasama naman talaga siya, member naman talaga siya doon sa Sangguniang Bayan or Sangguniang Panlalawigan for that matter. Okay? So any question?
Hello, baka yung sinasabi ni Daryl yung in case of tie, magbo-vote yung Vice Mayor.
Okay. Talagang magbo-vote siya. Doon lang siya pwedeng mag-vote in case of a tie. Yun talaga. That's very explicit, no? That's explicit in the provision of the code. Pero pag magboboto in determination of the majority, kung sino dapat ang majority, kung na-garner ba yung majority, hindi dapat kasama, hindi dapat boboto kasi hindi siya kasama, hindi siya dapat boboto doon sa issue na yon. Unless yun to break the tie, yung sinasabi doon sa code, no? Yung illustration na yun, talagang tingnan niyo yun kasi yun ang bago. May mga, although it was presented in that manner, pero may mga pinagbabasihan ng mga jurisprudence yan. Yung Carlota something, oo. May mga basis yan. At ang alam ko, that's the recent ruling ng Supreme Court.
Coach,
Yes po.
i-clarify ko lang din po kasi nalito po ako dun sa simple majority and qualified majority. Am I right po na kapag simple majority is the majority of the number ng present?
Yes.
Yung bumuo po sa quorum. Then
Tingnan
pag
niyo yung
qualified
presentation.
majority,
Okay.
included po yung absent. Tama po ba, Coach?
No. Sa qualified majority, diba, distinguish natin yung sa Constitution at saka sa local government code na yung sinasabi nating majority is yung computation. We're talking here about the quorum, ha, yung sa majority ng quorum, hindi doon sa pagbubutuhan na yung isang question. Kasi requirement pa rin in the determination of the quorum, the majority. Now, ang qualified majority na sinasabi natin doon, kung halimbawang 8 members of the Sangguniang Bayan, for example, may dalawang hindi na-proclaim. Hindi sila naging qualified, no? Hindi sila naging proclaim. Hindi sila kasama doon sa total number of numbers of sanggunian na magiging basis natin in determining the 50% plus 1. Exclude natin yan. Pero yung nagpa-file ng leave of absence, isama natin yan. Yung sinasabi lang natin qualified kasi hindi natin sinama yung mga like hindi na-proclaim, okay? Yung halimbawa yung may case, isang case na sinayton, there was a suspension, di ba? The preventive suspension for that matter, hindi na natin siya isama doon sa pag kukompute natin ng total number of the sanggunian for that particular instance.
Pero
So
coach,
iba
iba
yes?
po usapan pag yung sa voting na. Yung sa quorum po kasi medyo okay na po kami doon, malinaw na po siya. Pero pag 'di ba may qualified majority votes po tayong inatawag. So kapag qualified majority votes, included po si absent.
Doon sa titingnan natin yun ha. Tingnan natin yung illustration para maano tayo. Okay, yung sa first na illustration, okay? All the members, 'di ba dalawa to, may quorum tayo at saka majority vote, no? Sa quorum wala na tayong problem doon. Oo. Doon sa majority vote naman, all members are present. Ang assumption dito, all members are present pag sinasabi nating majority vote, 'di ba? Huwag tayo malilito doon. Pagka doon naman sa qualified majority, the assumption is may mga members were not proclaimed. No? And kinukuha natin doon is the qualified majority vote, meaning kasi hindi kasama si Vice Mayor dito sa pag-determine ng majority vote. Yung 5 SB members na lang at saka ex officio members. So hindi natin isama yung 3 SB members who were not proclaimed. So 7 lahat yung present. So yung question mo, of course, the members present, yun ang pagkukuhanan natin ng simplified, ng qualified majority vote. So 7 yun, kasi 7 naman ang nandun, 5 from the SB and 2 from the ex officio. 7 divided by 2, 3.5, kaya nagiging 4. That's for the qualified majority. Doon naman sa simple majority, ang assumptions natin dito are 3 SB members were absent. May 3 members na absent. Magkakaiba tong absent na to pagdating doon sa quorum, kasi yung absent dito sa pagkukuha natin ng majority, hindi natin isama sa pag-determine natin ng numbers, ng total numbers, no, of the 50% plus 1. But titingnan natin, kaya mas mataas ang quorum under dito sa first column 6, nagiging 4, kasi dito sa first column sa pagkuha natin ng quorum, sinama natin yung absent kasi nga yung mga absent naman hindi siya kasali doon sa sinasabi nating qualified. Yung sinasabi nating qualified, yun lang yung mga hindi na proclaim, yung may mga legal restrictions na wala talagang magawa kasi yung absent sinasabi natin pwede naman yung i-coerce, there is a force, di ba? May police papuntahin doon para magkakaroon ng maging present sila. So ganun yung difference doon. For the majority, hindi talaga natin isama yung wala. Oo. Majority of the members present, there being a quorum. Kailangan pa rin natin i-establish before they can legally transact a business yung quorum. Diba? Yung quorum. But in the determination of the majority, it should be the members present, there being a quorum. Klaro na ba yan?
Klaro po, Coach. Klaro. Thank you
Okay,
po.
thank you very much. Thank you. So ibig sabihin, dalawa yung titinian no doon, no? Yung quorum na sinasabi natin before they can legally transact a business, at saka yung majority na sinasabi natin na na kailangan upang they can enact an ordinances or they can even adopt a resolution. Iba namang majority na sinasabi natin. Of course, we will not consider those who are not present, only those present. But yun pa rin, majority there being a quorum. You have to determine first the quorum. Okay.
Noted, Coach.
wala nang questions, clarifications, makakatulog na kayo.
Good luck sa quiz.
Okay, we have 5 minutes before 5 and you need to prepare also, no? So kung wala nang questions, hindi naman kami magpapaalam, no? Kahit na last synchronous selection session na ito. Babalik pa rin kami for the discussion of the quiz results and hanggang sa before the module exam. So okay, so maraming salamat with meron ka pang sasabihin, PD Jun?
No, I'm good. Thank you very much for your participation and good luck sa exam natin.
Okay.
Thank you po, Coach.
Good luck.
Thank you po,
Salamat
coaches.
po, coaches.
Ingat kayo lahat.
Thank you po, coaches.
Thank you po.
Thank you po.
Salamat